Mm. Hi guys, I'm Professor Zubair Jahangir and I welcome you to the EBCL marathon. Tomorrow is your exam, you have your exam next, and I can assure you I will be covering the most important parts, something which will definitely come or probably come in your examination. Now, to begin with, let me tell you EBCL is a subject which will help you score because you know how your securities law paper went. Securities law paper went a little difficult. Now you have to know that as a professional, you have to focus your mind on the next paper and try to score maximum marks and exemption. And I am here with you to help you score an exemption which will help you get and clear the examination. Second, let's see what is the plan for the day. Now in your EBCL subject, I'm taking you through the breakdown. The very first thing is your breakup and which topic you should start first. Firstly, your EBCL subject is divided into part A, B, C. Part A is around 11 chapters for 40 marks. Your competition law is one chapter for 25 marks, and your business and commercial laws is 12 chapters for 35 marks. Now, from all these three, since you're starting your preparation, obviously anyone who's going to start the preparation has to start with the first chapter, competition laws. Since it's one chapter for 25 marks, you can score 18-20 marks, and that can really help you clear this examination. Now if I go to see the breakdown and the subject chapter wise weightage, so the part A chapters, where you have around 7 chapters, come for around 70 marks. The very first common sense chapter is your competition law, 25 marks. So your 7 chapters come for around 70 marks. We will start with the very first chapter, that is your competition law. We will also see your other chapters of your part A chapter. Now this is a marathon and a revision, so I want you to bring whatever notes you had before. तुमने कहीं से भी पढ़ा होगा वो notes को तुम सामने रखो of competition law, and with me you have to finish this. For 25 marks I will be doing the past exam questions. So what all I have with me right now, I have the institute study material, the module which you need to open and keep. Second, I have the past examination questions, all the past exam questions, which have come for 25 marks. Once we do the chapters, we will see whether we have covered the past exam questions also. Okay. So very important chapter, competition law, 25 marks is in your pocket. You have to start your preparation right now. Then the third thing that I have with me is your ICSI has instituted a supplement sheet for EBCL. So I will also be referring to that, and whatever is the major amendment to be remembered, I will be covering that as well. Okay. So good to go. Is my sound perfectly clear? Can we begin with the first chapter? You need to have your module. In your module, open your competition law chapter from where you have studied. तुमने कहाँ से पढ़ा है, कोई classes की notes, take that, keep it in front of you, and a book and a pen where I will give you important things and markings and sections which you can quote in your examination. So I'm waiting for your comments. Are we good to go? Everything perfect? Can we start? Yes or no? Okay, great. So let's begin with the chapter. Just let me set it up first. Okay, I go here. Okay, great. So keep your books and pens ready, and we begin with our notes as well. 25 marks in your pocket, you have to finish with me. No matter what, you have to ensure that you get out of 25, you have to score full, like wherever the maximum marks possible. It will help you score a lot. So I'm going to cover the entire competition law, and it's going to be a real fast with, I will give you exam importance as well, something which comes in the exam. Okay. So firstly, when we talk about Competition Act 2002, it's very important to understand the background of the act. What was the act before this, and why was this act passed? Which was the committee which brought the existence of this act? So in our constitution, in the directive principles of state policy, article number 38 and 39 stated that it is the duty of the state to ensure that the goods and services are available at fair prices. Under article, so you will quote it in your examination. Okay, so write it down, whatever you think is relevant, which you can quote. So in the constitution, in part 4, which is the directive principles of state policy, it was stated that it is a duty, the state should ensure that the goods and services are available at reasonable prices. So then the courts, the government started thinking कि कभी goods are not available at fair prices. When the goods are not available at fair prices. So whenever there is a monopoly in the market, just one supplier, he could really dominate the market and really decide the prices and even increase the price. So at the time of monopoly, the goods and services are not available at fair prices. So the government thought, why not restrict monopoly? Monopoly is the problem. Let's make a law to restrict monopoly. So then the Monopolies Restrictive Trade Practices Act 1969 was passed. After that, it got global criticism that you are trying to restrict monopoly. I worked so hard to get monopoly, and it was a negative concept to restrict someone. Moreover, even the internationally, this law is not very much encouraged. Instead, abroad, there is another law called as antitrust laws. In USA, they call it as antitrust laws, which says that we don't uh, break monopolies. We encourage competition. अगर competition आएगा market में तो automatically monopoly टूटेगी. If competition will come, automatically the monopoly will break. So, in 1991, after the post-liberalization, where we said we will liberalize and make it easy to do business, the government of India, under the chairmanship of SVS Raghavan, passed the Competition Act 2002. So, under whose chairmanship it was passed? Under the chairmanship of SVS Raghavan. And the focus changed from restricting monopoly. We said we will not restrict people, let him do whatever he wants. We will bring in new people. We will encourage people to come and do business. Accordingly, whoever is bringing at high price, he will have to lower the price because he will not find business. So जो भी high price पे बेच रहा है वो survive नहीं कर पाएगा अगर market में competition है तो. Now, on the recommendation of SVS Raghavan, the MRTP Act was replaced by the Competition Act 2002. The focus shifted from curbing monopolies to promoting competition. Now, what is the objective of the Competition Act 2002? There are two things. One is to encourage competition. Competition लाओ market में तो prices कम price में मिलेगी चीजें customers को. And the second objective was to prohibit, restrict, stop all those practices which had an adverse effect on competition. So all those things which were bad on competition, which used to have unfair practices, उसको हम रोकेंगे. Competition encourage करेंगे, we will encourage competition, और जो unfair trade practice को prohibit करेंगे. So what is the objective of the act? everywhere in your answer possible you will write introduction, objective of the act. The objective of the act as stated in the Competition Commission of India versus Steel Authority of India. Now whoever is listening, stop. Listen to me. In tomorrow's paper, you have to compulsorily write this case law. ये case law तुम लोग सबको लिखना है. Because ये objective है, object of the act, you can quote anywhere. So according to the Supreme Court of India under the CCI versus the Steel Authority of India, the objective of the act is as follows: to eliminate adverse effect on competition, to eliminate practices, to stop the practice which have a adverse means harmful, जो भी गलत practices है उसको रोकेंगे, to promote competition, to protect consumer interest and to ensure freedom of trade, and also to establish competition of CCI. Clear till here? Now this is the objective. Now talking about competition, what do you mean by the term competition? Competition is a place, is a marketplace where both all of the people are trying to attract the customers. So competition is a process of economic rivalry. Economic fight chalta hai, everybody, there is a cutthroat competition in today's market. So there is a economic rivalry, there is price penetration. People are saying you're giving for 10, I'll give for 8, some is giving for 6, some is giving for 4. Some people are saying we'll give for free. So competition is a process of economic rivalry between the market players to attract the customers. In common parlance means common understanding, competition in the market means sellers striving independently for the buyer's patronage to maximize profit. So competition is a place in the market where the sellers are trying to get striving independently to get the customers support, attention, profit. Clear till here? Now if we go back into the history, they have asked the history also, that is why I am stressing here. Now competition law and policy, the World Bank and the OECD, now all these references you should quote. ये सारे references तुम्हें quote करने हैं. The World Bank and the OECD in its report, A Framework for Design and Implementation of Competition Law and Policy, pointed out a dynamic and a competitive environment underpinned by a sound competition law is essential for the characteristics of a successful market economy. Such high English, but very simple meaning, that competition is needed for a good economy. Now, as per the Asian Development Bank, during economic transition or reforms, the benefit of an open market cannot be fully realized unless the restrictions on competition are removed. To get the to fully realize the economic power, it is important to remove all those barriers. Clear till here? Competition policies are a much broader set of instruments and include all the policies. Competition law is about all those policies which help encourage competition. Competition law is only a subset of a national competition policies. Now what does this line mean? That there are multiple things that the government does to encourage competition, and competition law is only one part of the nation's competition policy. There are multiple other laws also which the government involves. You have Consumer Protection Act, you have certain Unfair Trade Practices Act, okay, all those other acts are also there. So competition law is only one part, is a subset of the main national competition policy. Now again, what is the purpose of the competition law policy of India and the Competition Act? The basic purpose of competition policy and competition law is to preserve and promote competition and encourage competition and prevent all those activities which have a adverse effect on competition. Now before we start into the act, I want you to bring your module, and in your module mark certain important things with me. Okay. Very first thing they start off, the objective, that Competition Act has been enacted with a view of economic development of the country, to prevent practices which have an adverse effect on competition and to promote competition. Next, introduction. They say that there is a growing recognition that a flexible, dynamic and competitive private sector is essential to foster economic development. So a theory can be asked, how is competition law important? So all those OECD and all those your Supreme Court judgment, you can quote that it is necessary for economic development to untap the this. Now I'm telling you which you can quote in the exam. Okay, then they have given the definition of competition law. Then again you can quote a few people from here just to build your answer in case if they ask you the background. They have asked the background, that's why I'm saying. A number of empirical studies have found a positive relationship between competition and innovation. So wherever there is more competition, जहाँ पे भी competition है, now since you saw how difficult professional exams are, since it's a competitive exam, in such a time you will start improving yourself, you will become much more better self, you will develop more skills. So innovation, productivity and economic growth will be more where competition is more. Then even this, the basic purpose of competition law is to promote competition, and two sets is to encourage competition, and second is to prevent anti-competitive practices. Till here I believe we are done with the background. Clear? So they have asked in the past exam questions. So let me take you through what was the past exam questions. In the past exam they have asked, what is the objective of Competition Act? What is the objective of Competition Act? It was a past exam question. So write the sale authority of India, Supreme Court judgment giving the objective. Second, they have asked again in the background, they have asked why is competition essential in the market? It is a question. Why is competition essential in the market? So write that all those people we saw, this journal was there, then that wherever there is higher competition, there is higher innovation and economic growth. Then one more question I believe is there on the background of the act. Background of the act, and that is here. This is the one. The basic purpose of competition policy is to preserve and promote competition, which means ensuring that there is an efficient use of allocation in the economy. Discuss. So you will write what is the basic purpose. So same thing you will write about competition law. Till here it is clear. Now we start with the Competition Act 2002. I will be going a bit faster now. Now first you have to remember the sections. Now the important sections I have written here which you have to learn. Section number, so your definitions are there. First, one important definition with the section I'm telling you have to remember is section 2 subsection C. Can anyone put in the chat box what is that? Section 2 subsection C, what is that? Put in the chat box. Can you tell me what is the section 2 subsection C? It has been asked 3-4 times in the past exam question. Quickly. So it talks about cartels. Excellent. Then they start off with anti-competitive agreements. That no enterprise shall enter into anti-competitive agreement. That is subsection 1. Subsection 2 says if you enter into an anti-competitive agreement, it is void. Subsection 3 talks about horizontal agreements and subsection 4 talks about vertical agreements. So we will see what are horizontal and vertical agreements. Then they said that the competition in section 4, they said that abuse of dominant position. According to the Competition Act in section 4, no enterprise shall abuse their dominant position. Abuse, simple word, what do you mean by the term abuse? Misuse. And dominant position means what? Position of strength. Position of strength in the market. So if you are at a dominant position, you have a monopoly, then you cannot misuse that power to have an adverse effect on competition, or to have an appreciable effect on competition, or to have a harmful effect on competition. Then comes section 5, which is your combinations. Combinations are large mergers and amalgamation. In large mergers and an amalgamation, the government is saying, listen, there is a chance that it might affect competition. So beforehand only, you take our approval. We will allow you, but if it is a combination, approval of the Competition Commission of India is needed. CCI approval is needed. Then came regulation of combination. If a combination has entered without taking the approval of CCI, that combination is invalid, void, wrong. Then this Competition Commission of India is the competition law regulator in India. Just like for consumer matters, you have consumer court. For company matters, you have company court, NCLT. Similarly, for competition related issues, you have a court called as CCI, Competition Commission of India. It's a quasi-judicial body. Now we'll be starting with a section. Very quick I will go. Section 1 says it extends to the competition. It will be called as a Competition Act. Now let's understand cartels. It has come many times in exam. So it's a exam question. So exam question. Now cartels. Cartels, the meaning itself. So whatever I'm going to stop and explain that has come in the exam and that is a chance of coming, only then I will stop and I will go. Otherwise I will move ahead. So cartels means what? All these people come together, all the sellers. Let's say for example, these are the sellers or the distributors or the manufacturers. Okay, they all come together and they say, why fight? Ladenge kyun? Why should we fight? Let's come together and make an agreement. So all the sellers, distributors and this who are supposed to compete with each other, they agree not to compete and to manipulate either the price or the production or the distribution of certain goods. So cartel section 2C, an association of producers, sellers, distributors, traders, service providers, they all come together and they have an agreement among themselves that chalo hum log ek kaam karte hain, everybody will sell at high price, so all of us will earn, nobody will give less price. So they try to control, limit the production, distributions, price of goods or services. Till here it is clear. Now there is something called as international cartels. In India, when these Indian traders do cartels, it is completely prohibited, it is void, it is illegal. But tell me one thing, is international cartels allowed? I want you to put in the chat box, is international cartels allowed? So let's read. What is international? It is a past exam question many times. I will show you, you will be shocked. So there are two kinds, import cartels and export cartels. Import cartels, understand, out of this I am giving you a hint, one is allowed, one is not allowed. According to you, which one will be allowed? When the importers make an agreement to control the price, production, this. Obviously, since the importers are going to sell in India, this will be not allowed. So import cartel, when the enterprises get together for the purpose of import into the country and selling them at a specific price in India. So import cartel you cannot bring at high price. Very good, people have correctly answered. But if I say export cartel is when exporters say बहुत high price में abroad बेचेंगे, we'll sell at very high prices abroad. That is okay, now you're selling to foreigners, so that is allowed. So based in one country with an agreement to cartelize markets in other countries. So you want to cartelize abroad, do that. That's allowed. Okay. Now very important, there are certain factors which are conducive to cartelization. Means very high English, 2-3 times they have asked, so better to understand and finish it now. What does this mean? Conditions conducive to cartelization means, tell me one thing, if in the examination the supervisor goes out, it will lead to copying, yes or no? Many people will start copying. Agreed? Yes or no? Answer is yes. So that is a thing which is conducive to copying. People, the examiner going on, matlab kya? It will encourage. It is a very good condition for that thing to happen. Similarly, cartel create होने के लिए certain चीजें जरूरी होनी चाहिए या ये सारी चीजें होगी तो cartelization easily हो पाएगा. If there are less number of sellers, distributors, so 3-4 people, there is very easy. But in today's market, can you do cartelization? So many players. So current market is not conducive to cartelization. High entry and exit barriers. High entry and exit barriers mean what? Very easily people can come in. So then I cannot do cartelization because very easily people will start the business. So मैं अगर decide भी कर दूँ high price में, किसी ने नया business चालू करके they will start selling. So even if I decide to sell at high price, people will come in since the entry barriers are not there. They will start doing business. Homogeneity of products. Everybody has the same product. Similar cost. I don't have any excess capacity. सबके पास में रहेंगे, they will sell. High dependence of consumers on that product. Okay. And history of collusion. So all these things, if it is there, it could lead to cartelization. Good chance cartelization will be there. Okay, so this is a past exam question as well. Let me take you through the module. Okay, now let's go to the module. I'm giving you some important stuff. Market it from your ICSI module. So why we need competition in the market? So this also they have asked in the exam, past examination question. Now we started from here, the definitions. In the definition we came to cartels. Now can you see some of the conditions conducive to cartelization? So this is a past exam question as well. Moving ahead to section number 3. Now anti-competitive agreement. Section 2, you have to remember section 2C. Now we are seeing section number 3. Section 3 talks about anti-competitive agreement. Subsection 1 says no enterprise shall enter into anti-competitive agreement which is likely to cause adverse effect on competition. Adverse मतलब harmful effect on competition. ऐसी चीज enterprise मतलब businesses को नहीं करनी चाहिए. Subsection 2 says if you do, it is void. Any agreement entered in contravention to subsection 1 will be void. Now subsection 3 and subsection 4, pay attention, okay? I want you to take a screenshot so you can build it up. Anti-competitive agreement, subsection 3, subsection 4. Subsection 3 is horizontal agreements when it is an agreement between the same business owners. So it is between the direct competitors. It is between direct competitors. Okay. Now, like for example, two businesses who are competing with each other decide to fix the price. So Coke and Pepsi both decide to increase the price. So they are direct competitors. They are horizontal agreement decided to fix the price. Or market allocation. Market allocation means you take this much area and do business, and I will take this much area and do the business. The next one is artificial shortage. So when we decide to do limit the production, and bid rigging. Now bid rigging has been separately come in the exam. Bid rigging means to rig the bidding process. When the bidding process is manipulated, it is called as bid rigging. Vertical agreements are for, it is not between direct competitors, it is between complementary businesses. Complementary businesses working in the supply chain of the product, in supply chain of product. Okay. For example, between a raw material supplier and a manufacturer. So they are not competitors, but they complement each other. They come in the same customer को product देना है. So till there, many businesses join hands, suppliers, marketers. So they all help each other. So they complement each other. So when these two, the supplier and the manufacturer agree, the manufacturer and the distributor agree, so that all is called as vertical agreements. This horizontal agreements by default is void. Void per se means they are always void. Vertical agreements can be allowed, can be permitted subject to conditions. So if the court has allowed, in certain cases they allow. First is tie-in agreement. With selling one product, I chipkao another product. So as a requirement to purchase one product, the customer is required to purchase another product as well. Exclusive supply agreement. So exclusive supply is, I have an agreement that I will supply to you. You cannot take supplies for anyone else. So manufacturers जो होते हैं वो लोग कभी कभार ऐसा करते हैं, they do like that. They tell the distributor, I will only supply to you. Exclusively I will supply. If you take from another people, I will cut contact with you. So this is between you and me, manufacturer and supplier, manufacturer and distributor, saying that I will give to you from other people, don't buy. Exclusive distribution. In exclusive distribution is like sole selling agents. I give you a right that in this area only you will sell. And so the agreement is between people in the same line of business, not direct competitors. Refusal to deal. Let's not enter with XYZ person. And resale price maintenance, where the resale price is fixed. Clear till here? So this is there, you can read it up. Horizontal agreements are agreement between competitors. Price fixing, where you fix the price. Artificial scarcity or control, where you limit the production or control. Market allocation, where you divide the geographical area. And bid rigging. I'm coming to bid rigging. What does bid rigging mean? Bid rigging is a process. Now this is also a past exam question, a past examination question. In this, what they had said, that when the bidders who are supposed to compete with each other, if one is saying 10, other will say 12, other one will say 13, product is being sold. So bidders compete with each other, yes or no? So when the bidders do not compete with each other and have an agreement to manipulate the bidding process, they decide कि यार bidding process को थोड़ा rig करते हैं, क्यों ज़्यादा price में, you want this product, nobody else will raise the price for that, you will get the product at less price, I will also bid, that time nobody will challenge, so I will get at a less price. So what happens when the bidders who are sitting are colluded, are fraud, the seller will face loss by not getting the real price. So bid rigging is anti-competitive and it is not allowed. So bid rigging means when the bidders collude the bidding process. The objective is to keep the bid amount at a certain level. It is intentional manipulation. If you see the definition of bid rigging is agreement between the persons to eliminate, reduce or adversely affect the bidding process. And it is held that bid rigging is a anti-competitive. Now, most common ways of adopted in bidding: give identical bids, give agreement to as to who will give the lowest bid, agreements not to bid, okay, squeeze out the other bidders, ensuring that no other person comes as a bidder. Agreement assigning, uh, designating the bid winners in advance. पहले से ही बोल देंगे he will win and all of us will shut up and sit. Then comes vertical agreements. Vertical agreements we've seen. Tie-in agreement. As a requirement to purchase one product, you are required to purchase another product. Exclusive supply agreement, where I say that I restrict the purchaser from dealing with others. Exclusive distribution agreement, where I restrict the supply to a certain territorial region in a prescribed territory. Then comes refusal to deal, restrict the right of a person to deal with others, and resale price, where I decide the resale price. Now moving ahead to section number 4, which is talking about abuse of dominant position. The word abuse means misuse. Misuse, and dominant position is a position of strength. It's a position of strength. So when a really big player like Reliance Jio comes in and tries to dominate in the market by harassing other small players, it is treated as anti-competitive and it is not allowed. So abuse of dominant position is wrong. In MRTP Act, dominant position itself was wrong. The name of the act was Monopolies Restrictive Trade Practice. So we used to restrict monopoly only in the very start. Here we are not restricting monopoly, here we are restricting misuse of monopoly position. Okay. So now no enterprise shall abuse its position. There shall be an abuse of position if, so it will be assumed that you have misused your position if you impose unfair conditions, unfair price you try to limit the production or any development relating to goods is called as abuse of dominant position. Now when I say dominant position, how do you define that? Dominant position means you can operate independently into the market and affect the competitors. Okay. Then there was a small question about predatory pricing. What do you mean by predatory pricing? Can anyone put in the chat box what do you mean by predatory pricing? It was a past exam question. Predatory pricing means pricing below the cost of production. Selling at a price below the cost of production. Reliance Jio, what it did, it gave for free. उनको cost नहीं था क्या? They didn't have cost, they had the cost. But their objective was to destroy. Uninor बंद हो गया. कितने Idea and Vodafone had to merge. Airtel was almost on the verge of losses. So many other, your Tata had to shut telecom, Reliance had to shut, Reliance telecommunication had to shut of Anil Ambani. So obviously the predatory pricing objective is to destroy competition. Once the competition is destroyed, then they will rise the prices. So predatory pricing is also not allowed. Is selling the goods below the cost of competition, and that is with the intention to eliminate and kill and reduce the competition. Okay. Then is what constitutes abuse of dominant position. What amounts to abuse of dominant position? So putting unfair conditions, predatory pricing, all this amounts to abuse of dominant position. Limiting the entry barriers, limiting any kind of development in the market, technical production market, applying dissimilar condition to similar transactions. Means if Mr. A comes, I will give you this price. But if someone else comes, B comes, I will give you at 10. So I have similar transaction but different conditions. Terms and conditions are being put in. So you are being unfair. Denying market access. Telling anyone, get lost, we won't let you operate in this area. Okay. Then again they've given you a point which comes in the exam which you need to sit and read. For the purpose of determining whether an enterprise enjoys dominant position, the commission shall give due regard to the following factors. Understand? Think and tell me. Very good. So when will we say that someone has abused their dominant position? So when the market share is, they have what all factors will you see to believe that whether they are big enough or no? So you will see their market share, you will see their size, you will see the importance of competition, what is the size of competition, you will see your money strength, economic power, you will see how much dependent the customers are in him. Okay, you will see the integration of the enterprise on the network. Vertical integration means you will see their suppliers, their distributors, how strong network they have. With that, you will be able to determine whether a business is enjoying dominant position or not. Okay, so all of this countervailing buyer position. Now the language is a little high, but exam में तो ऐसा ही लिखना है ना. So you have to develop your language. Countervailing buyer position means what? I'm in such a strong buying position that I can suppress the price from the seller. When Reliance Industries is buying goods, don't you think they will tell the seller that, listen, give me at such a low price, otherwise I will go to someone else. So counter buying power they have. They have more strong power understanding in the market than the seller. So the sellers are sometimes oppressed and sometimes bullied in the market by these dominant players. Okay, so this is important. Then come into combinations. Now what are combinations? Combination in simple words can be treated as large mergers and amalgamations. And how do you determine large? A threshold has been given in section 5. If you touch that threshold, you are a combination. And if you are a combination, you have to take approval of CCI before merging. CCI is expected to regulate large mergers and amalgamation which have a appreciable adverse effect on competition. Appreciable, English meaning possible. So they have told what are combinations. So they have given you a limit. The threshold limits are something like this. I believe you must be having that. It's very simple and I believe all of you all must be knowing the limits. I'll explain threshold limits for combination. First, if a enterprise combined when A and B get merged, their assets is 2000 crores, then it can be treated as a combination. Or its turnover is, if you just put this number into 3, is 6000 crores, so we can say that it is a combination. So either of them, either the assets are 2000 crores or the turnover is 6000 crores, we will be treated it as a combination. And if it is a combination, you have to take approval of CCI. Now, if it is no group, then there was no group involved. But if I say Tata Group, there are more than 2 companies involved. So there is a group involved. Tata Group, Vedanta Group, HUL Group, whichever, and groups are joining. So then we will say if the whichever and groups are joining. So then we will say if the assets are 8000 crores or into 3, if you see always into 3, the turnover is 24,000 crores. To remember this downwards, you have to remember it is into 4 for this down. So 2000 into 4 is 8000 and this. So just by learning one limit, you can fill all the others. How? If I just learn this limit, 2000 crores. So 2000, this side will be 6000, this side will be 8000. Once it is 8, this will be 24. Clear till here? Clear till here to learn this table? This part is clear? So either the asset or the turnover is limit is hit, it is a combination. Large merger, obviously देखो ना, 2000 crores के assets, 2000 crores, it is a big merger. If a group is involved, then 8000 crores. Now, if I tell nowadays companies have international presence as well. They are not necessary. This was where it was a pure domestic merger. But nowadays we have cross-border mergers as well, where companies have global presence. So in that case, this will be the case. Assets, total assets, if no groups are there, it is $1 billion. You will do into 3. Again, this will be same into 3, or the turnover is $3 billion. You put into 4 down, into 4 here, 4 billion, and from here into 3. So this will be $12 billion. Clear till here? So just by learning one limit, so if I know it is $1 billion in case of a in and outside India, MNC, multinational company. So it will be 1 billion, there will be 3 billion, down it will be 4 billion, there it will be 12 billion. Till here it is clear, yes or no? Now when we are seeing this thing that the billions we are calculating, the asset and the turnover, we will also see the minimum component in India also should be there. Minimum component in India means ऐसा नहीं कि 1 billion पूरा abroad ही है, that everything is abroad. At least minimum presence in India is of 1000 crores, and here they have given minimum component in India. If you're taking the turnover, it should be 3000 crores. Till here it is clear. This table is important. They have not asked in the exam, but they can ask you. Then they say increase in threshold of de minimis margin. Increase in threshold of de minimis margin. What is that? Now we've given the limit is how much? Let's take one. This is 2000 crores. Okay, of the both the entities combined. So here, if I say that Reliance Industries itself has 2500 crores. Okay, so if I say here the limit is what? Combined assets should be 2000 crores. I'm saying Reliance alone Reliance has 2500 crores. So even if it is merging with a small company, the limit, because since we are taking the combined limit, it will get triggered and they will have to take approval and all this. But Reliance will say, hello, it's not a big merger, it's a small merger. I alone am big. I am taking a small company. Ultimately, it's a small merger. So then why you're putting me into this procedure? So then the law said, okay, fine. They removed a notification that acquisition, whenever there's a takeover, whose assets are not more than 350 crores, they are exempt from section 5 of the Act for a period of 5 years. Means, if they pick up a company which is of 2 crores, so what is the limit given? If the target company assets are up to 350 crores, very small company, or turnover is up to this, then you don't have to comply with these provisions. Till here it is clear. Target enterprise is a very small enterprise, means it is only max 350 crores or turnover is max 1000. That means it's a very small company. The large entity is only acquiring, because of that only the limits are getting hit. So therefore we are saying in such case your section combination of chapter or section does not apply. De minimis matlab what? De minimis, minimal is there, minimal net worth is there of that target enterprise. So it's not a big merger. It's a big company acquiring a small company. Now whenever you're merging, you have to give such intimation should be given within 30 days of the proposal relating to merger and amalgamation. So you have to inform, notice to CCI has to be given within 30 days of the meeting. Exemption from filing notice. So section 2A provides that the notice relating to the proposed combination needs to be filed within 30 days. Section 2A further says that a combination shall come into effect until 210 days from the day on which the notice has been given to the CCI or the orders passed, whichever is earlier. Now what does this mean? CCI, I gave a notice to the CCI that हम लोग merge करने का सोच रहे हैं. So we are planning to get married. This is the information. Within 30 days of that decision, we are informing the CCI. Now CCI also should give a time bound reply. CCI should also reply. So CCI gets 210 days to reply. If they don't reply, it is a deemed approval and the combination will be valid. It will be believed that CCI doesn't have any objection. So the combination will have effect from 210 days if no approval is given. However, approval is given before, so then that earlier date will be taken into consideration. Okay. Now, however, on the said notification, the Commission has relaxed the 30 days norm. This notification has been done away with the deadline to file within 30 days, provided that the parties given the flexibility to file the combination when they are ready to give a notice. So this 30 days timeline has been relaxed, and they say that whenever you're ready, you inform, but only after information the combination will be effective. Now, you ever wondered why this chapter is for 25 marks? One chapter is for 25 marks. The answer is section number 43. Pay attention to what I'm saying. I'm asking why is this one chapter for 25 marks under EBCL? कभी सोचा तुमने? The reason is section number 43A, and this is a past exam question also, you have to remember. Now listen to the penalty. Penalty सुन के ही तुम लोग के हाथ से पेन गिर जाएगी. Power to impose penalty for non-furnishing of the information on combination. So section 43 provides that if any enterprise who fails to give notice of the combination, the commission shall impose a penalty which may extend to 1% of the turnover or the assets whichever is higher. Imagine combination में assets कितने के हैं? 4,000 करोड़, 2,000 करोड़, उसका 1% की penalty है, or assets or turnover whichever is higher. Did you understand why this chapter has so much weightage? Because penalty is how much? 1% of total assets or turnover whichever is higher is the penalty. So it runs into crores. So therefore they are training you from now only to be an expert in the competition law. Then moving forward to exemptions. Now section 6 does not apply to certain companies which they believe is financial institution companies. We are giving them good enough time. So banks and all of them, when they are merging, this does not apply. So whenever it is a public financial institution is being acquired, foreign institutional investor, banks, venture capital funds, okay, pursuant to any loan agreement, all this takeover is done. So loan was defaulted, so the company took over the shares. So in all these cases, section 6 does not apply. Approval of CCI is not there, because it's a very common thing. Section 6 subsection 5, the public financial institution, FIIs, banks, venture capital funds, etc. are required to fill in the prescribed form, but they are exempted from taking approval from CCI. Now moving ahead to the next one, then I come to the exam questions, which brings me to the most important part of the chapter, which they can ask you. It is your inquiry into the combination. So the combination may have inquiry. So if the CCI is the Competition Commission of India, they look into all these competition related aspects. Agar unne dhunda कि there is an inquiry, they came to know that a business is having a adverse effect on competition, it can conduct an inquiry suo moto or on basis of a complainant, informant. Okay, suo moto, or if someone has gone ahead and complained, informant is there, it will begin their inquiry. Now procedure for investigation. Procedure for investigation, section number 29. First thing, what it will happen if there is a complaint that CCI is received. Okay. So first, CCI will look into the opinion, whether itself form an opinion, make a prima facie opinion, whether there is a adverse effect or it is not. First, CCI only has to believe. Then if they feel that yes, it is there, then they will give a show cause notice of why investigation should not be conducted. After receipt of the response, the commission may call for the report from the Director General. Then they will call the Director General. Director General is the officer in competition law who will further look, because CCI is just an institution, it works through its officer. Officer is Director General, will look into the matter. If the commission is a prima facie of the opinion that it is going to have an adverse effect on competition, it shall direct the parties to publish the details. The combination may invite any person affected. So anyone who is affected, they will hear both the parties to file his objection, and then after hearing both the orders, it will pass an, after hearing both the sides, it will pass an order. Section 9 subsection 19 subsection 3. The commission shall give due regards to the following factors which we believe is going to have a adverse effect on competition in the market. So all these are factors in determining whether a combination is having a bad effect on competition. What all could be there? So we will have to look into whether kitna competition hai, how many barrels have you done, how much power do you have, what are your profit margins, whether there are substitutes in the market. So they will require a full knowledge about the market before determining whether it is going to be harmful or not. The possibility of a failing business, benefits to the consumers, the advantage that you're going to get, the development which is there, etc. Now, after finding it under section 30, you can pass an order. Order could be allowing it, approving the combination, or telling that the combination cannot have effect, or last one telling that you can effect subject to you do these changes. So they can give an order to modify. Then comes your extraterritorial jurisdiction. Very, very important. Okay, very, very important. Extraterritorial jurisdiction. Section number 32. 32 says that the CCI shall have power not only in India, but at some time they will have power extraterritorial as well. That means beyond India as well. Whenever any agreement, any party, any situation is entered abroad, but is having a effect in India, adverse effect in India, so Competition Commission of India can look into and investigate into the matter. So the Competition Commission of India can inquire and pass an order, okay, if there is, which is into any agreement which is going to have an adverse effect in India. If it has been entered outside India, agreement was entered, party was outside India, the abuse is out, the dominant position is outside India, the combination has taken place outside India, the party was outside India, to the combination was outside India, any other matter, only if all of that is causing an adverse effect in India. The above clearly demonstrates that the acts taking place outside India but having an effect, adverse effect on competition in India is subject to the jurisdiction of CCI. Who can appear before the CCI? So again, very, very important. You can mark it as important because for the party, company secretary can appear. So all the company secretaries can appear in the CCI also to represent their party. Suppose if there is a case on GO and CCI, so the company secretary can appear. So who will appear? The complainant, the defendant, and the director general. Now all these people who are authorized, the following persons are authorized to represent the client: the chartered accountant, company secretary, cost and works accountant, and a legal practitioner. So if you see, CS has got legal recognition under the Competition Act 2000 to represent their clients in the court. Now, appointment of Director General. Now, obviously, CCI is a commission. It's an institution like a court. They require Director General to look into, do the inquiries and give them the updates. So, Director General is an important functionary. He is there to assist the commission in conducting inquiry into the contravention of any provisions of the Act. So, market is important. Okay. Then discuss the powers and functions of the Director General of India. So very, very important. What all powers does he have? So firstly, the Director General, he has all the powers to investigate into the affairs. The Commission is having the same powers as vested in the court, civil procedure court. So whatever powers the court has, even CCI has. For example, summoning a person, bringing them on affidavit, examining them on witness, checking their documents, okay, collecting evidence, search, seizure, all of those powers they will have. Then Competition Commission of India, section number 7 is central government shall constitute CCI. The composition of CCI they've given, who will be there in CCI at the court. So it shall consist of persons having of a chairperson and other members, not less than 2 and more than 10. They shall be appointed by the central government, and they shall be persons having ability, integrity and standing, okay, in India, and have a specialized knowledge and professional experience of not less than 15 years in international trade, economics, business, law, accountancy, public affairs, etc. So this has been a past exam question as well. Okay, so the powers of CCI, what all powers do they have? You can mark it again. They can inquire into competition, impose fine, order the division of a company, determine whether an agreement is having an appreciable effect or no, inquire whether a combination is having an adverse effect. They can grant interim relief as well. Okay, duties of the commission we've seen. Section 18, duties of CCI: eliminate practices, promote competition, protect interests of consumers and promote free trade. Then talking about the appellate authority, from in CCI you can go in appeal. First it was CAT, Competition Appellate Tribunal. Now it has stopped from an amendment, and now all appeals from CCI go to NCLAT, National Company Law Tribunal, within 60 days from the order of CCI. From there it goes to the Supreme Court within 60 days from the order of CAT. So this is the appellate jurisdiction. From CCI it goes to NCLAT, and from NCLAT it goes to Supreme Court, both within 60 days. Competition advocacy means to give advice. So CCI can give advice to the central government whenever the central government is making laws on the competition related matters. So how it is worded, that the central government may ask the CCI for opinion and for advice on competition related matters. CCI can give recommendation to the central government. During policy formation, the central government may make a reference to CCI. Within 60 days, CCI is bound to reply. Then comes relevant market. So relevant market is the market in which the competition has been affected. This could be a product market or a geographical market or both. Now product market means what? There is a problem in the product only. Okay. Then comes geographical market, means there is a problem in a territory only, and there could be both. For example, if there is a problem with X3 CPU units all over India, so we will say the problem is in the product market. Understand what it is. अगर हम लोग बोल रहे हैं, if we are saying that competition has been affected, what you will say? Either where it has been affected. So we will say, because we have to understand where the Director General will find out the relevant market, that where the competition is wrong, show me. So you will have to say, ये product में problem है, onions में जैसा था, onion में problem है, सब prices cartelization कर रहे हैं. Territorial means bid rigging. यही एरिया में जो मीटिंग हुई थी उसमें बिड रिगिंग हुआ है. So it is not with one product, it is with the area. In this area the cartels are there. So this is with respect to area, and sometimes it could be both. One product का ही problem हो रहा है in one area. So that is it. So the Director General will have to first identify where is the problem. Only then he can identify. Now how will he identify? He will say that, how can you identify? You will say that the conditions for competition is same here in this area, but the conditions of competition is working very differently in this area. So then he will try to do investigation in this area. So when the conditions of competition, how will you demarcate? Because ये तो कोई दिखता नहीं है. It's not like a murder that you can find out where exactly the wrong has taken place. So in this business you will have to segregate that. See, in this particular thing the conditions of competition is same, in others it is very different. Okay, so geographical market, this market. Then they've given you for determining a geographical market, they will look at the local requirements, trade barriers, national policies, language preferences, all with related to a territory. Then similarly, when we talk about product market, we will talk about the goods, the price of the goods, the customer's preference for the goods, the production capacity, the producers, the classification of the industrial products, etc. Okay, so with this I'm done with the Competition Act 2000. Now we'll just go to the exam questions to see whether we've covered everything or no. Okay, in the module also, first let me take you to the module. You can mark certain additional stuff if you want. I believe you must be having. So anything which you see like a box, please study that, it is important. Okay, 25 marks it is there, you have to finish it with me. Okay, this also what is anti-competitive agreement, all we've covered. Okay, all of this we've covered. What is a combination? Threshold also we've covered. De minimis margin also we've covered. Any doubt you want me to take up, please tell me. Okay, now exemptions also we've covered, the 30-day exemption. Now moving ahead to one part, even this if you go to see 19.3, the factors to determine whether it is having an appreciable effect on competition or not. So all these factors you have to sit and learn. Okay, so from where you must have studied, you continue studying from there only. Okay, now one last, I just wanted to take you to one case law. Now appearance before this, which we've already done. Okay, company secretary can appear, so be very careful, they can ask you. Remember the section number also, section 35. Okay, now see, the CCI can regulate its own procedure. It will have the same powers that of a civil code. Then moving ahead to penalties, super important. Okay, now penalties also, you see why one chapter of competition is having 25 marks. See the penalty. The competition prescribes penalties for contravention of the orders. Section 42. Remember I told you 43A is also a penalty provision for combinations, and this is for 42. That if any person fails to comply with the orders or the direction of the commission, now very important. Okay, then he shall be punishable with a fine which may extend to 1 lakh per day, which can go up till 10 crores for a subjection till, so 1 lakh per day up to a maximum of 10 crores penalty. Imagine how important this chapter is. If you are the company secretary, compliance officer, and you by mistake also, God forbid, you do a non-compliance in this, see what is a 1 lakh per day, which can reach up till 10 crores as the commission may determine. That is why take this chapter seriously and finish it off properly. Okay, then even 43A, I told you, non-furnishing of details, this is for combination, that shall impose a penalty which may extend to 1% of the turnover of the asset, whichever is higher. So crazy level penalties, you have to take this chapter. Now competition advocacy also we did section number 49, and that's it. And then just in the end they give you a very baby case law. So in this case law, in the Sameer Agarwal versus Competition Commission of India, they have not worded it properly, but they've just said that any person can become a informant, but to file a complaint, it is stated that he has to be an aggrieved person. Okay, because in the laws they are saying any person may give information to CCI, and they are saying when they use the words aggrieved person for section 53B and 53T. So whenever we say appeal and all of that, they use the word person aggrieved, and here they're saying any person. They're not using the word aggrieved. So a informant doesn't have to have any loss, or does not have to be aggrieved. Just a small part they can ask. Okay, so don't spend too much time on that. But I'm just saying. Now let's go to the past exam questions which were there. Okay, so everyone's with me. Whatever you've studied, let's finish it now. Describe the jurisdiction of the Competition Act to inquire into appreciable adverse effect on competition. Okay, which place outside India. Which section number? Everyone put in the chat box. Which section number is extraterritorial jurisdiction? I want you all to put it in the chat box. Extraterritorial jurisdiction. So it is your section number 32. If there is any act which is done outside India but is having an adverse effect, appreciable adverse effect on competition in India, it will be the CCI will have jurisdiction. Next, what are the powers and functions of the Director General? I want you to put the section number in the chat box. What is the functions and power of the Director General? I've told you, very, very important. So section 36, okay, Director General is bound to comply with the directions of the Commission. They will have all the powers of a civil court for summoning a person, document, summon a person, summon a document, get it on affidavit, examine them on the witnesses, and take evidence under the Act. Okay, so which section is functions and powers of Director General? Put it in the chat box. See, it's in the sequence only. It's in the sequence only. Now coming to the objectives of Competition Act. Can anyone type what is the case law that you will write for objective of competition law? In short, I want you to put in the chat box. Very good. What is the case law that you will write when they write when you have to write about this? About the objectives of this. In the start of the case we are done. We are done. Quickly, I'm waiting. What is the name of the case law? One case law I told you all to remember. That is your Steel Authority of India versus this. Very good. Then predatory pricing. What do you mean by predatory pricing? Predatory pricing, it means selling below the cost of production. What do you mean by anti-competitive agreement? Which section is anti-competitive agreement? Please put in the chat box. Which section of and subsection talks about anti-competitive agreement? I'm waiting. Please put section 3 subsection 1. Very good. Discuss the duties of the Director General. If he fails to comply without reasonable cause and with the directions, what punishment is to be given by the Competition Act? So what is the punishment section I told you to remember? 2 punishment sections I told you to remember. Put in the chat box which are the 2 punishment sections. So one is section number 42. Very good. Perfect. Section 42 talking about how much penalty you will get. So 1 lakh rupees per day, which can go up to 10 crores, and this 43A, which is for combination when you violate. Now coming to this elite, they had asked another situational question. Now remember, they can ask you situations also, so you should know how to write it. Now I'm reading the case law. You all have to be with me. Elite Club is a club of 8 Indian banks. The club covers the entire Indian territory for its operations. The club covered entire India with a view of fixing the rate of deposit, lending rates, etc. So what are they doing? They all came together and they started fixing the rates, interest rates. Now this is a club of 8 banks. The club also provided services for money transfer. One of the customer of the bank, which is a member of the club, made a complaint against the club acting as a cartel. Explain the validity of the complaint. What are they saying? That these banks, elite club was a club of 8 banks, started deciding that what interest price they will do. So very simple. First, facts show that there is a cartelization. Facts show that there is a agreement to control the price. So first you will write the definition. I told you cartels is which section? Cartels is which section? Please put in the chat box. Very good. So it's section 2 subsection C. And then you conclude that the complaint made by the customer is valid, it's prima facie valid. Keeping in view the definition of the term cartel, it may be said that the activities of limiting, control or attempting to limit or control the banking services would constitute cartels. Now going to the next question, what has come in June 2021 attempt is explain the concept of cartels with reference to Competition Act. So cartels, again we've seen section 2 subsection C, but we will also mention about international cartels, import cartels and export cartels. Then what constitutes composition of the CCI? So remember, section number 7 is about establishment of CCI, 8 is about the composition. So composition also we did that a chairperson, 2 members, not more than 6, the chairperson shall be appointed by the central government, etc. Clear? And he should have 15 years of experience with a experience. So this is important, just read that. Then next question they have asked in the exam, why competition is in the market is essential. Now I know you can also build up because it's a general, but I want you to quote some agencies, some case laws to explain. Okay, to do that, the OECD example was there, Sale India example was there. So you can quote those people to say that more the competition, more will be the innovation. What do you understand by the term vertical agreements? Give certain types of vertical agreements. What is a section for horizontal agreement and what is a subsection for vertical agreements? So section 3 subsection 3 and section 3 subsection 4, this is for horizontal agreements and this is for vertical agreements. Clear? What are the factors to be taken into consideration by the CCI for determining whether an agreement is appreciable? Appreciable means possible adverse effect on competition. So section 19 subsection 3, whatever box is given in your module, you have to learn that because it comes in your exam. Very, very good. What is the matter? Matters CCI may direct the division of an enterprise enjoying dominant position or does not. So section 28 says that the CCI may order and direct the division of an enterprise which is having an adverse effect on competition. So if they have merged wrongly, combination has been done wrongly, the CCI can ask them to demerge or separate. They've given you all these points. Describe the penalties imposed for non-furnishing of information or making of false information with respect to combination. Combination penalty is given under section number 43A. What do you mean by, now this is a December 2021 question. Cartels, what do you mean by cartels? Section 2 subsection C. What do you understand by agreements, anti-competitive agreements? Section number 3. You will write. Then what do you mean by the term combination? Now section number 5 explains combination. 6 gives you the 5 gives you the thresholds and meaning. 6 gives you that it will be void. What is collusive bidding? Now when they use the word collusive bidding, they are simply meaning of bid rigging. Bid rigging. Can anyone tell me the section and subsection and subclause of bid rigging? So it was the 4th point, right? So section 3 subsection 3 subclause 4 D. Okay, so that is bid rigging. What constitute abuse of dominant position? Section number 4, and critically analyze the provisions. What are the factors to be taken into consideration by CCI in determining the dominant position? Discuss. So then they give you what all is dominant position. Then we've done that purpose of competition policy is to preserve and this. So the basic purpose of competition policy is to promote competition. Competition policy has typically two elements. One is a set of competition enhancement. Second is stopping anti-competitive agreements. So all of this. So all of this is covered, and that is it. We are done with the entire Competition Act 2002 from with the past exam questions. Okay, so your 25 marker is done. So 25 marks is done. Okay, so I've covered this for you with all the past exam questions. Okay, now you need to take a short break. I will take a break. You will sit and revise the entire Competition Act 2002 from now till the break. You have to sit and study that. Finish it off. By the time I come next, I will pick up another chapter, which is the second biggest chapter of EBCL. Second biggest chapter of EBCL, that is your FEMA. I will complete and finish the second biggest chapter also, which is foreign exchange transactions. Okay, so this is for 10 marks, which is there. So from wherever you are studied earlier, your FEMA, you will keep that next before we come. And before we do, you have to finish your Competition Act. Also, inform your friends also of the lectures. Many do not know. They will also be helped. Share the video in your groups. Inform your friends that very nice lectures are being conducted. You can attend and it will help you. Now, FEMA chapter we will start. Okay. Now, FEMA chapter we will start. How long do we have to revise? So till you perfect it. See, listen, 25 hours, 25 marks. You can score 20. 18 marks you can score. You will pass on one chapter. Please understand. Rest all you will be able to attempt something or the other. Yes or no? कुछ ना कुछ तो लिख ही लोगे ना 5 mark के कुछ ना कुछ तो you will be able to write. As long as out of this 25 marks you score 18 marks. So take your time. I think we'll meet at 7 again. You must have studied Competition Act before also. Go through it half an hour or 7:15 we return. After FEMA, I will go fast on other chapters. Okay. So I'll meet you at 7:15. Clear till here? Hit the thumbs up in case you haven't liked the video. I'll see you back at in 7:15. Cool. Hello. Hello. Okay. Okay. Hi guys, am I audible to you all? Can you all please put in the chat box if I'm audible? So, FEMA, if you go to see, actually covers two important chapters. Okay, it covers two important chapters of your part A. So around 12 mark comes from FEMA. So we will be finishing the FEMA chapter. Okay, with all the past exam questions. Okay, great. So we will begin now. Okay, so this is your module, the FEMA chapter. Let me come to the FEMA questions. We'll just see what are the FEMA questions before starting. So whenever we are doing that particular topic, we'll go it in detail. Okay. So one is the object and scope of FEMA they have asked in December 2021. Then they have asked discuss the provisions of modes of acquiring property under the TISPRO Act. Okay, now this acquisition and this has been repealed. Okay, your acquisition and transfer of immovable property regulations 2015 is repealed, and instead of that we have the in the FDI chapter it's covered now, debt and non-debt regulation. So if I take you to the debt and non-debt, now this is about the FDI part. Okay, now pay attention to what I'm saying. That first, your now this I'm taking of FEMA. In FEMA, your this thing, tell you what has been repealed. So the FDI non-debt instruments and the debt instruments regulation. So you have your FEMA non-debt instruments regulation 2019 and your debt instruments regulations 2019 and your FEMA mode of payment and reporting of NDI regulations 2019 has replaced the earlier regulations, that is your TISPRO regulations. Now this is no longer in existence, and even your acquisition and transfer of immovable property regulations 2018 has been repealed. So instead we have your debt and non-debt regulations only from where you have to study. Okay, so this part is now omitted or repealed, and now you have to write the debt and non-debt regulations given in your FDI. Now briefly explain the scope of compounding given here. So compounding they have asked. Then they have asked state the prerequisites for a compounding process. Then they have asked enumerate the drawal of exchange which are prohibited. So prohibited current account transactions they have asked. Then they have asked state, now this is in December 2021. Okay, now they have asked explain the rules with respect to acquisition and transfer of immovable property. Okay, so now you will write the non-debt instruments regulation. This will be your answer. Non-debt FEM non-debt regulation rules 2019. So this is the correct answer for it given in your FDI. Then comes your modes of acquiring property. A frequently asked question. You always have to write your non-debt regulations for this. Then the various modes of acquiring property outside India. Again, whenever it comes to buying property, this they are asking about section number 6. That's your capital account transaction. But this immovable property is there. Of immovable property, then your non-debt regulation 2019 will write. Okay, so these are your questions. Let's start. Good to go. Can we start? I need a thumbs up from you. Then we'll quickly begin. Okay. So in your module, if I go to capital account transactions. Yes. Good to go. Can we start? I require a thumbs up from you that we can begin. Any questions you have, please put in the chat box. So I'll start and finish it in one go. A 12-mark chapter will be done like this. Waiting for your thumbs up and we'll start. Okay, great. Thank you so much for participating. Let's begin. So we'll be starting your FEMA Act 1999. Here I'll be completing it with all the amendments. So, and it's an important 12-marker chapter. So better take a book and pen and write down what all is the provisions which I will tell you. Also, we will be covering all the past exam questions from this chapter. Now, initially, let's understand the FEMA and its background. So, before the FEMA Act 1999, we had an act called as FERA, Foreign Exchange Regulation Act. Now, FERA Act was about conservation. The objective of the act was to conserve foreign exchange. मतलब क्या कि all the foreign currency को इंडिया में ही कंजर्व करो. So many times they did not like, they discourage exports, they discourage imports because foreign currency could go outside. So anywhere, wherever foreign currency went outside, this used to discourage. It was very stringent and any violation of the FERA laws were treated by default as a criminal offense. So if you have violated FERA, it is to have a criminal offense. It had 81 sections, came in January 1st, 1974. Okay, and it was a FERA Act 1973. So this was about FERA. Then came liberalization, privatization and globalization, where they wanted to liberalize, that is simplify the international trade, and wanted to bring a free trade where the global barriers were removed. So the globalization is where we can have a free trade from with other countries. So then we had Foreign Exchange Management Act. So now instead of regulating it and having stringent laws, we will manage it and encourage the development of foreign currency and the foreign exchange market. So our mindset changed from conserving, saving foreign exchange, that why do all this? Let's manage foreign exchange and manage international trade. The FEMA came on 29 Jan 1999, replacing the FERA Act. It came onto force in June 2000. It has a small Chotu Sa Act, which is which has 49 sections. And violations of the FEMA Act is considered as a civil offense. Now, if you go to see the legal structure, we'll be doing your Foreign Exchange Management Act 1999 in complete detail. Now understand, it's a small section, it's a small act, has only 49 sections. Only 49 sections. I'm going to tell you the sections that come in the exam. You need to take a book and pen and write it down with me. Now your section 3 to 9 talks about provisions regulating and managing foreign exchange. This is important. And your section 10 to 12 is important, which is about provisions for authorized persons. So take a book and pen, section 5 and section 6 you write. Now section 5 and section 6. And this Section number 10 is about authorized persons, authorized dealers. Till here it is clear. So if you go, what is section number 5? You need to write down in your book with me. Section number 5 is about current account transaction and section number 6 is about capital account transaction. Multiple times they have asked about capital account and current account transaction. So section has to be remembered, and when they asked about authorized dealers, you will write section number 10. Clear till here? So first we get the numbers correct, the section numbers in place. So this is about current account transactions, current account transaction, and this is about capital account transaction, and this is about authorized dealers. Till here it is clear. We can write the section numbers correctly if they ask about this. 3 sections only I am telling you to remember. From here only it will come and you have to quote in the examination. Clear? Let's move ahead. I'll directly go to the main provision that come in the exam. Now in foreign exchange, the FEMA is about import and export. Whenever the goods from abroad come into India, there is an import or there is an export. We can say this is an international trade where foreign currency, foreign exchange will be dealt. Okay, foreign exchange will be dealt. So whenever we have dealings in dollars, in pounds, in euros, in yen, okay, whenever this is all called as foreign currency. So whenever foreign currency is there, FEMA Act will be applicable. And the regulator for foreign exchange, whenever there is a transaction involving out of India, can you all put in the chat box who is the regulator? So the regulator will be RBI, Reserve Bank of India. Fine. Now let's understand the current account transaction. I believe you must be having an idea. If I buy assets, if I buy property, it will be current account or capital account transaction. Please put in the chat box. If I am buying property, immovable property, it will be capital or current. So it will be a capital account transaction. If I am buying shares, it will be a capital account transaction. If I am taking a loan, it will be a capital account transaction. If I take a guarantee, it will be a capital account transaction. So capital account transactions are all those transactions which alters assets or liabilities. Any other expense which does not alter the asset or liability, it will be called as a current account transaction. So current account transaction is a transaction which is not capital account transaction. Okay, this is a simple definition. So let's take examples of that. International travel for money, international travel, if I'm taking money for traveling, it will be current or capital account transaction. Travel expenses. Then I am abroad or someone is working abroad, they give money to their spouse. Medical expenses. Then payment of any commission to agent. Now these are all routine, salary to employees. Now these are all regular recurring expenses which hit the profit and loss account. So they will all be treated as current account transactions. Capital account transactions are those balance sheet items. They are called as capital account transactions. Now whenever they write a short note on capital account, current account transaction. So firstly you will write the section number. You will write section number 5. Section 2J read with section 5. Very, very important. So current account transaction means a transaction other than capital account transaction and includes foreign trade, payment of interest on loans. So interest on loan, interest will keep paying every time. Loan is a capital account transaction, but paying interest on loan is a current account transaction. Paying for remittances for living parents, for when you're abroad you want to send money regularly in India to your family, that will be a current account transaction. Expenses with foreign travel will be current account transaction. So how do you start? This is the first, you will write the meaning, then you will write examples of it. This is the second part. Third, you will write that to regulate current account transactions, there is a regulation made, that is your FEM Current Account Transaction Rules 2000, made to regulate current account transactions. So section number 5 gives the definition of current account transaction. Then they further go to say that government has made special rules, the FEM Current Account Transaction Rules 2000. Okay. Now if we go to see the rules, now we are studying the FEM Current Account Transaction Rules 2000. In this, they are saying that there is about prohibition on withdrawal of foreign exchange, approval of government, and provide approvals of approval of Reserve Bank of India. Okay. Now understand, approval by this. So I'll just take you to the main thing. In the current account transaction rules 2000, it has 3 schedules. Schedule number 1 talks about current account transactions which are prohibited. 2 talks about transactions which require prior approval of the central government, and 3 talks about which require prior approval of the RBI. Till here it is clear. When they ask, write a short note, you will write definition, then you will write examples, then you will write about the rules. In rules, you will say there are 3 schedules. The first schedule are saying current account transactions which are prohibited. Second schedule will say which require prior approval of central government. Third rule is saying which you require prior approval of RBI. In your module, they have only spoken about schedule 1 and schedule number 3. So we will also focus on these 2 schedules only. Now schedule number 1 we will be doing. So 3 schedules of the rule. The first schedule we are doing. This is a past exam question. Multiple times it have come that the current account transactions which are prohibited. So name current account transactions, prohibited current account transactions. Till here you all are with me. In the last attempt only, if I show you in the past exam question, they have asked, explain the transaction which are prohibited. Okay, so this is a regular question here, this one. Now enumerate the situation in which foreign exchange is prohibited under the foreign exchange current account rules 2000. Till here you all are with me. So now we'll be doing. Pay attention, okay? Now in this, each entry I explain in detail so that a person understands. But now since it's a short revision lecture, I will go directly to the point. Otherwise, I explain each and one with proper examples where you will understand it very well. Right now, it's a revisionary lecture, so we have to learn 8 points. So I'll focus on the learning part. Okay, so current account transactions which are prohibited. First, now the first 3 are very simple. And obvious. कौन से transactions government prohibit करेगी if you want to buy from abroad? So purchasing of lottery, remittances out of lottery. So you want to buy lottery winning, not allowed. Remittances out of income from horse racing. So horse racing prohibited. Lottery winnings, if you want to give it abroad, not allowed. Income from horse racing, not allowed. Remittance for purchase of lotteries, banned. Magazines, football pools, sweepstakes, etc. So if I want to remit money abroad, socho, now I'm explaining what does remittance mean. Many people don't know the meaning of remittance only. Abhi English is little bit high. The English here is little very powerful. So we have to understand. Remittance means to give. Okay, or remit, transfer. So when I want to transfer money foreign exchange abroad. So government will ask why you're remitting money. So I'm saying I want to buy lottery. They're saying not allowed. I want to get into racing. Abroad allowed. All of this is allowed. To purchase lotteries, banned magazines. So if you want to buy banned magazine, not allowed. If you want to get into football pools or sweepstakes. Now what does it mean? In abroad, you can, how we can't bet on IPL. In IPL, if you do in India, it's illegal. But abroad, you can very well buy in all these Manchester United. You can bet Chelsea. Betting is legal abroad. Casinos is legal abroad. So you cannot use that foreign exchange to engage in these transactions. Next, payment related to callback services of telephone. Now I'll give you one quickly. So just remember callback services, payment of commission on exports. Callback service, I'll explain. This one I'll explain in detail. So you will understand. Now understand what is this callback technology. Now callback technology is, normally, let's say this is me. Okay, this is me. This is me. And this is my wife. I'm writing my wife's name. It's Katrina Kaif. Okay, so my wife is Katrina Kaif. Now imagine she's abroad, she's in London, and I want to talk. International calls, if I make, it is expensive or no? Yes or no? If I make international calls, it's expensive, yes or no? So obviously it is very, very expensive. So I can't afford, and I want to talk to her for hours. So then what to do? Because outgoing calls are very expensive. International outgoing calls are very, very expensive. So what technique I remove? There are some companies, what they do, they go and set up. This is a company. JT is a company which gets situated in a low cost jurisdiction. So they will get list in a low cost jurisdiction. They will set up their company. I just have to make a call on this number. So I have to make a call on this number and it will cut. So I make a call and it gets cut and then they will call me back. So outgoing call, मेरे को पैसा लगा ही नहीं, मेरे को outgoing call का पैसा नहीं लगा, because I just have to give a missed call on that number and then it will cut. Then this company will call me. Now incoming in India is free or less money, so that is fine. And what this company will do, it will also call Katrina Kaif in UK. So this is in a low cost jurisdiction and it will call me and get a conference call. There will be a conference call with Katrina and me. So what it has done, this intermediary who is in a low cost jurisdiction will call two people and put them on conference call. So for me, I also received a call. For Katrina Kaif, she also received a call. Now receiving calls is cheap. So this company charges some commission. In India, we do not earn any revenue. So callback services is not allowed in India because we do not earn much. Zoom. I agree. Now this business is very much outdated now because of Zoom and other things. Very, very good. I believe you might have someone. That's how you must have found a better solution. Earlier, this act is a little old. That time people used to, when Zoom was not there, they used to use this callback services. Good point. Next is payment of a commission on exports made towards equity investment in joint ventures abroad of Indian company. Okay, now I'm not explaining in detail for these points because there are multiple points. Now, payment of commission on exports. Now understand what is happening. There is an Indian company and this Indian company has a subsidiary abroad. I made a sale and that guy has to pay me. So I would have got foreign exchange in India. I tell the person I need an export, I am the exporter. So I should have received some money, foreign currency in India. I tell them don't pump the money to me, pump it in my subsidiary. You put that money in the subsidiary. So he will give me, so against my exports, I am not getting money. They are benefiting by investing in my subsidiary. So that is the consideration to me. So in India, we didn't get any money only. So on this export, if there is any commission, why will the government allow? So this is a prohibited current account transaction when you want to make payment on a commission on exports for which money is not received in India. That who I exported to, he is not going to give the money in India, he is going to pump it in my subsidiary abroad. So India is not benefited anyway, so we are not going to allow the payment of that payment of commission on export. Right now I'm not going in detail, I'm just quickly telling you just so that you learn these 8 points. Next is remittance of dividend by any company to which dividend balancing is applicable. So remittance of dividend by any company is prohibited to which dividend balancing is applicable. Now understand this point. Dividend balancing means what? If there are these foreign companies in India, they have earned foreign, they are in India and they are making exports and they're earning foreign currency in India. So let's say they have earned foreign currency of 20 million US dollars. So a company in India has done exports and has got 20 million USD in India. So we will be happy. But then they want to give dividend abroad of $21 million. So what they will say, what Indian government will say, you think they are fools or what? You have earned foreign exchange of $20 million and you want to remit abroad as dividend to your whoever shareholder is there of 21 million. At least balancing rakho yaar, thoda keep it normal. So dividend balancing means keeping a balance between how much dividend you give. So we will not allow remittance of dividend beyond how much currency you have earned in India. So just remember these points. I'm not explaining each point in detail. I'm just quickly going through. Just you should be able to write the point. Then next is payment of commission on exports except up to 10% of invoice on tea and tobacco in the rupee state credit route. Now what is this? There was a transaction between the Indian government and Russian government where Indian government had taken some goods for which they had to make payment. They could not make the payment, so then they told the Russian government that listen, we can't make you the payment. What we will do is we will keep giving you some goods. So like tea and tobacco, we will keep giving to you against whatever money you have to, what we owe you. So that was a rupee state credit route. So how it used to work, the Indian used to make exports to in Russia. So the Russian government used to get tea and tobacco. Russian government will not pay us anymore. The Indian government pays us because the Indian government has got already money from the Russian government. So in that case, Indian government की जेब से निकल रहा है. So Indian government has limited the commission, payment of commission. They've said not allowed. It is except if it is up to 10% of the invoice value, because government has to pay, Indian government has to pay. So I'm not going in detail, I'm just telling you upar se, but you remember the point. Payment of commission above 10% is not allowed, Indian government won't pay. Next is remittance on interest income in the non-resident special. So in these kind of accounts, non-resident special rupee account scheme, we tell the Indian residents who are there, non-resident, you open this account, you earn interest also, spend it in India. We will not allow the interest income to be gone out of India. This is the benefit. If you want to be in India and earn foreign currency, you earn foreign currency, then you put in FD. Whatever interest amount is there, use it in India. We won't let you remit abroad. Now from all these points, I've gone in detail, but I just want you to tell me the numbers. Okay, so first, lottery, betting, gambling, not allowed. Banned magazines, sweep pools, keep writing, typing what all it is there. Okay, sweep pools, your football stakes. Okay, uh, etc. is banned. Then comes your third one. Also, I told you very simple. Can you all message in the chat box which one it is? So racing is not allowed. Racing. Okay, so three were simple. I believe you can write horse racing, etc. Remittance for all these purposes are not allowed. Then we had some four different things. One is callback. The other one is under the rupee state credit scheme up till 10% it's allowed. Then another thing is the dividend balancing, remittance of dividend to which dividend balancing applies. Then in case of exports, commission on exports where it is being the money is being not coming in India, is being invested in subsidiary abroad, in JV abroad. Okay, so any point am I missing? And interest income on this. Okay, so all these things are not allowed. Interest income in the rupee, this special scheme account is not allowed to be remitted out of India. Till here, have you understood? Please put in the chat box yes or no. So quickly I can move ahead. It's a very common question that is asked in the exam. I want you to put in the chat box whether you've understood and you know the points or no. Quickly before I move ahead. Yes or no? Quickly put in the chat box. Have you all understood till here or no? All I want you is to remember all these 8 points. Perfect. Thank you so much. Now these were all examples which I explained in detail, but right now we are going through a rapid speed, so we are not going to do that. I told you schedule number 1 of the FEM current account transactions rules 2000 talks about prohibited current account transactions. So you will say it is rule 3 read with section number 5 and schedule 1. Now is your schedule number 3 which talks about approval from RBI. Transactions which require approval from RBI. Now they have given you certain thresholds. Certain amount of thresholds. If you thresholds is certain limits. Agar limit ke upar gaya then you require RBI approval. So only if you go above the limit then you require RBI approval. Otherwise RBI approval is not needed. Individuals who can avail foreign exchange facility for the following purposes within the limit of 2,50,000 only. Okay, 2,50,000. Even if you remember your liberalization remittance scheme, it will have the same prohibitions that we did above, and it also has a limit of that they can remit. Indian can remit abroad in the LRS scheme up to 2,50,000. Then comes any additional remittance in excess of the above requires prior approval of RBI. Okay, any additional remittance in excess of the above requires prior approval of RBI, whether it is for private visit, donation, employment, immigration, close relative, studying abroad, you're going for medical treatment, any other amount. Now, this was for individuals. For individuals, we have the LRS scheme. In LRS scheme, it is given individuals can remit abroad up to $250,000. Uske upar they require RBI approval. Now coming to other than individuals like body corporates. So for body corporates also they have given, if a body corporate, a company wants to donate in exceeding of 1% or $5 lakh, whichever is less, for chairs in certain educational institutes. Now chairs means what? Seat. Now there are some paid seats that you can get. Some amount they keep it as reserve. So if you want to get it, donations you want to give for chairs, so then they always pay this to keep some seat reserved. They put their employees, they send their children, directors' children, whoever it is, company reserves certain seats. They want to give contribution of funds promoted by any education institutes, uh, or contribution to a technical institution or a body corporate in the field of the activity of the donor company. So further, if you want to give donation to reserve your seat for an education institute, or you want to give it to a technical institution in the field of activity of the donor company. So let's understand, if I'm talking about a if I'm talking about a let's say a company such as Pfizer. Okay, now Pfizer is there, it is into medicines. Okay, so it's into that, so it can really fund, since the field is there, it can fund a institution, a technical institution, for donation, because the field of activity is the same. Then for agents, they have given you uh, again commission. If someone is buying a flat abroad, we will give commission. So the commission up till this limit is allowed. In exceeding 25,000 or 5% of the inward remittance, whichever is more. So commission per transaction to agents for sale of residential flats. So whenever there is a sale of commercial flat and we want to give to the commission, we want to give it abroad in excess of this amount, then you require RBI approval. Then again, they've given you for any consultation services which have taken exceeding these limits, okay, per project or for infrastructure. So they've given you reimbursement of pre-incorporation expense in exceeding 5% or 1 lakh, whichever is higher. So they have given you these limits. I'll tell you which limits you need to remember. All this is not really important. One, this limit obviously is your liberalized remittance scheme also will get over if you just do these limits. This is important. And from here they have asked for agents, one, for pre-incorporation expenses, how much you can do. Okay, now coming to capital account transactions. Capital account transactions are those, so now you write the meaning. As per section 2E read with section 6, they say that capital account transactions are those transactions which alters assets and liabilities. Now transactions here can be of two kinds. Permissible capital account transactions can be of two kinds. One is when it is being done by a person resident in India, and second which is being done by a person resident outside India. So if I say again, what are capital account transactions? If you bought a house, you bought shares, you bought loans, you've taken a loan, you've given a guarantee, so all these things, you've taken a life insurance policy, so it becomes an asset. So any of these transactions done will be considered as a capital account transaction. Now whichever is given in by a person resident in India. So for example, I've taken an example of SRK, Shah Rukh Khan, when he buys a house in Dubai. Okay, we know he's bought a house in Palm Jumeirah. So it is a class of capital account transaction done by a person resident in India. So he's resident in India and he's buying property abroad. So it is a capital account transaction, it will be coming here. So simple things such as buying foreign security, loans, if he's taken a loan, transfers the immovable property, guarantees, loans, overdrafts, foreign maintainer of foreign currency accounts, insurance policy, life insurance policy taken from insurance company outside India, payments for capital assets, sale and purchase of foreign exchange derivatives or commodity derivatives. All these things will be treated as capital account transaction because they hit your assets or liability. Now this is same thing if you reverse it by saying it is a person resident outside India, and just reverse the words, that if we are investing abroad, it's a capital account transaction. They can also invest here, they can buy shares, foreigners can buy, so it will be here. When we say Brad Pitt is buying in India, then these points will be there. classes of capital account transactions of person resident outside India doing transaction in India. Clear? Then we have acquisition of immovable property. This is important, but it is no longer there in the FEMA part. It will be there in the FDI part, where you have your non-debt regulations. Okay, it's newly done, which I've told you. See this one, your non-debt regulations, your FEMA non-debt instruments regulations 2019, referred as NDI norms. Clear? So it's important, can come. Now going to the next thing. So section 5 and 6 we finished. Now we'll be doing your another important part, which is your section number 10 directly. Before we come, just one part I want to tell you. This also they've asked once. Remittance by companies. So when a foreign company has set up its operations in India, we had seen there were so many companies which had set up their company in India. When they shut down, they would want to transfer all those assets, income abroad. So they are all called as remittance outside India. Remittance means to transfer, give. So they want to transfer their funds abroad. So there might be a subsidiary in India which might have shut down and they want to go abroad back. So like AD, the authorized dealers may allow remittance by Indian company under liquidation by an order of court. So foreign company must have shut down, the funds of it can go abroad provided the auditor's certificate confirming that all the liabilities in India have been paid for or adequately provided for. Winding up was according to the Companies Act and there is no legal proceedings pending against the company. Okay, similarly for these points, now coming to this possession of foreign currency. So how much foreign currency can we hold in India? So this is a past exam question also. So possession and retention of foreign currency or foreign coins. So very simple, the regulation number 3 of the FEM possession and retention of foreign currency regulations 2015, RBI specified the following limits, how much foreign currency or foreign coins we can hold. So very simple, it's come in the past exam question. How much do you think the authorized person can do? Authorized persons is a person who is authorized by the RBI, permitted by the RBI to deal in foreign exchange. So they can hold foreign currency and foreign coins up to the limit given in by RBI to them. So within the scope of their authority, they can hold coins and notes, foreign coins and notes. Next is possession without limits for coins by any person. So chillar paisa, as much as you want you can keep. This was with respect to foreign currency for authorized person. Within the scope, coins we can keep till any limit. Then comes retention by persons resident in India of notes and checks not exceeding $2,000. So an individual, a person resident in India like you and me, how much notes, foreign currency notes we can keep and checks we can keep of an amount not exceeding $2,000, provided that such foreign currency has been acquired, all this foreign currency has been acquired during your visit abroad or from any person not resident in India as a gift. So someone has gifted you, up till this amount you can keep, and represents unspent money amount of foreign currency acquired from authorized dealer for travel abroad. So if someone will ask me how do I have up to this $2,000 or pounds, I will say that I had taken from the authorized dealer to spend abroad and this is my proof. So all that is allowed. So regulation number 3 says how much authorized dealer can keep up till whatever scope of authority they have. Coins can be kept till any limit. Notes can be kept up till $2,000, provided that we've acquired it from an authorized dealer we've taken it for travel abroad, we've got it as a gift from someone. So all that is allowed. This is a past exam question as well. Okay. Now coming to very important, I want you to take a note, take a short whatever time and finish this properly. Compounding of offences of FEMA regulations. So whenever you violate FEMA laws, compounding regulations are applicable. Now what is compounding? Compounding means settling the matter. So when कोई भी company ने अगर laws violate किए, if I have violated the FEMA laws, so it is possible that I might agree to my offense. I might agree that yes, I made a mistake. Take monetary charges and close the matter. So that I'll say take compounding charges and close the matter. So compounding means to settle a matter. And case, if it is if the prosecution is on, the case will be dropped. I want to end the matter. So sometimes you want to pay the fine and close the matter. So that is compounding. Compounding is a breach. Contravention is a breach of the provisions of FEMA. So if I have contravened, मतलब मैंने violate किया. Compounding refers to process of voluntary admitting the contravention, pleading guilty and seeking redressal. So I say I made a mistake, I'm sorry, take compounding charges and close the matter. The RBI is empowered to compound, to settle. Compound means to settle any contravention after providing an opportunity being heard. It's a voluntary process where the individual or the company has to admit to the contravention. They have to agree that they did the wrong, pay the fine and close it. Now, compounding has two benefits. From the government point of view, money is coming in fast by way of fine. Matters, the overburdening of court is reduced. And the second part is the violator, those who violated the law will also get a punishment because they have to pay this fine. So it has a lot of twin goal. The payment of compounded amount, whatever they have decided, you have to pay the amount. So where a contravention has been compounded, the sum involved in the contravention shall be deposited within 15 days. So in 15 days you have to deposit the amount. Otherwise, it will be deemed that it has not been compounded and a case will be reinitiated. So whenever it has been settled, RBI said okay fine, pay. 15 days you have to pay, otherwise it will revive, the case will revive. Next so here again, compounding refers to a voluntary process of admitting the guilt. Okay, RBI is allowed to compound. Now something which you have done, gross violation or intentional violation, which are severe in nature, cannot be compounded. So it may be compounded. Application has to be made to RBI. They've also given you a payable at at Mumbai, submitted to the compounding authority, the cell for effective implementation, Fed, Foreign Exchange Department, RBI, Central Office, Mumbai. So they've also given you the address to which you will make the application. Okay, so you have to read all of this. Prerequisites for the compounding process. For prerequisite means what all is required to compound. You have to admit to the offense. One, you shouldn't have made a similar offense in the past 3 years. Right? So you are a habitual offender, it will not be allowed. अगर मैं घड़ी घड़ी करते रहूंगा तो नहीं चलेगा. एक बार, if I want to compound now, in the past 3 years I shouldn't have compounded the offense. So in respect of a contravention committed by any person within a period of 3 years was compounded, then he would not be allowed to compound under the FEMA law. So if he is compounded an offense in the past 3 years, he will not be allowed to compound. So any serious contraventions suspected of money laundering, terror financing, affecting the sovereignty, integrity of the nation cannot be compounded, shall be referred to the Directorate of Enforcement for further investigation. So serious offences, you have a Directorate of Enforcement who will look into the money laundering aspects. RBI will look at different factors before giving this. They will look at the nature of the violation. They will see how much gain you've got. They will see how much loss has been caused to the public. They'll see the repetition nature of the offense. So these are all the factors that they will look before ready to compounding the matter. Okay, so that is it. Compounding is important. Authorized person is a person authorized to authorized by RBI to deal in foreign exchange. License has been given by RBI. It can be cancelled by RBI. RBI can ask for inquiry, do investigation on the authorized person. So section 10 deals with procedure for appointing authorized person. He has to apply, get a license. Section 11 talks about RBI can issue directions to the authorized person. They can conduct inquiry, investigation, and section number 12 says RBI can inspect the authorized person as well. Okay. And I believe, and the appeal provisions. Appeal provisions are also very simple. First is the adjudication and appeal. There is an adjudicating officer. So the adjudicating officer is the first person who we deal. So if I am a company and I have violated the FEMA laws, the notice I will get from the authorized adjudicating authority or the officer, FEMA officer. He has passed an order against me. So then I will have to go and appeal to the special director of appeals. If I'm unhappy with him, I will go to the appellate tribunal. If I'm unhappy with him, I'll go to the high court. So this is the procedure for appeal. The hierarchy for the appeal. You can read it once, and that is it. We are done with the FEMA chapter. The most important, again I'm telling you, you can write it down. Section 5, Section 6 and Section 10 to 12. Section 5 is current account transaction. Section 6 is capital account transaction. And Section 12 is authorized persons and compounding of offenses and compounding of offense. Okay, that is it for the FEMA chapter. We'll take a quick break and we'll start with another chapter. Let me check which one should I finish. Any recommendations from your end? Which chapter should I finish? Okay, so I'll go with the FCRA Act. Okay, so I'll take a 5-minute break and then we'll start with the FCRA Act 2000. Okay, and there is an amendment also with the FCRA Act which I'll keep it open in the supplement sheet. Okay, in the supplement sheet we have the FCRA Act, the first amendment only, FCRA Act Regulations 2020. In this, the most important point is the administration of powers. Registration of persons. It's the administration. Yes. So this is the important amendment. Important amendment in this. Okay. So we will start with the FCRA Act, and also I will put the section. Okay. So the section numbers also will do. So we'll take a short break and we'll come. Any recommendations? Any specific chapters you all want me to take? Any specific chapter? Registrations. Now we have registration of persons. Okay, so we'll take a break and we'll come in the next 15 minutes and finish it off. So we'll be starting with the FEMA Act. We'll take a 15-minute break. Okay, and we will start. NBFC. NBFC, I've taken a lecture. If you want, I'll. Okay, so let's see how much we can do today. I'll see you all in 15 minutes. You all can finish the earlier chapter that we did, FEMA. Second biggest chapter, complete it quickly. Any difficulty, let me know. Hi guys, am I audible to you all? I need you to just put in the chat box if I am audible to you all. I will be taking all through the amendment also, through the supplement sheet, the amendment for this chapter, which I believe it can come also. And I'll be covering the full chapter really quick. So I need you all to put in the chat box if I'm audible to you all. Okay, great. So let's start. Firstly, I'll directly take you to the amendment. Then while doing the chapter, we will see what is the particular implication and understanding for it. Okay. So three important amendments are there. One is for the FC contribution, which we will be doing now. The Consumer Protection Act also is there in the amendment sheet, which I will be doing next chapter that I will be picking up is your Teach Specific Relief Act. Okay. Let's see. Then next I will be doing the Consumer Protection Act, and this with respect to the FDI, I will be discussing what is the amendment. Okay, so quickly let's go to the Foreign Contribution Regulation Act. The main point is in section they have included the word public servant also within the ambit of within its ambit to provide that no foreign contribution shall be accepted by the public servant. So just note it down while telling the main example. I will explain what it means. While teaching, I will tell you where it is being hit. So your section 3 has been hit. Then another important one is how much administrative expense can be used. So earlier it was 50,000. Now they have kept it from 50. They've put it to 20,000. What it is, I will tell you later when I'm doing the chapter. But just remember two important amendments, section 8 and section 3. Okay, in this chapter. Let's quickly start and finish it off. Now, Foreign Contribution Regulation Act. Now, this is about foreign donations. Let me just quickly put across what is this chapter about. Okay. 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 So now we'll be doing your Foreign Contribution Regulation Act 2010. Okay. Now the FCRA Act, it talks about foreign donations. It talks about foreign donations. So the foreign donation means there must be it must be coming from a foreign source. There must be a foreign source which is giving a donation in India, right? Now this donation, what they have given, okay, could be in the form of goods or service, right? Either I'm giving a donation is coming. So donation could be coming in the form of goods where you've given some article or some asset to someone, gifted to someone, donation in India, or a service. I have given a hotel stay, medical treatment to someone. So donations could be in goods or service. Now this foreign source means a foreign government from foreign, basically a foreign NGO, a foreign individual, a foreign trade union, anything whichever is registered abroad is making a donation in India. Now when we say goods means what? They're calling it to foreign hospitality. The words they are using is foreign contribution is goods, okay, is goods, and For service, they are using the word foreign hospitality. Hospitality. Okay, till here it is clear. Now, whenever this donation comes from abroad, it is all regulated by the central government. It is regulated by the central government. So you need to take, now it's coming from abroad, it could be in foreign currency. The central government has made the laws, and RBI is also there. You require permission, prior permission. So in some cases, when you're receiving this foreign donation, government has said you have to take approval, and in some cases they have prohibited uh, foreign donations. For example, for certain people, like you cannot give a donation to an Indian judge, you cannot give it to the media. So a foreign source giving a donation cannot happen to certain countries. So this is done by, to ensure, the government wants that the Indian internal security, sovereignty, integrity of India should not be compromised. Compromise नहीं होना चाहिए, ठीक है? Because you cannot give donations to key people. So the government regulates donations with the help of this act. Normally, there are some genuine NGOs in India, like PETA, CRY, okay, all of them, they are genuine, being human. These are all NGOs. So if they want to receive donations from abroad, or there is a university, they want to receive donations, so either they take a approval or they get a license. That, see, we are in this NGO only, we will keep getting, so a license, a certificate has to be taken. For some, they have prohibited. So let's quickly go and finish it off. The object of the FCRA Act is to regulate or control foreign contribution, that is for goods, and foreign hospitality, that is for service. It seeks to regulate the flow of foreign funds to voluntary association, and objective of preventing any act which is detrimental to the interest of the country. It is a legislation for internal security and regulated by the Ministry of Home Affairs. Firstly, when I say a foreign donation is coming and it is a form of a foreign contribution, means what? It is in the form of any ACS. Remember the word ACS. Any article has come, any currency has come, or any shares or security has been given. For example, if a foreign source from foreign, someone is donating some laptops, so it's a article. If they are giving currency only, it is a currency or security. So foreign contribution is ACS. Foreign hospitality is they are giving a donation in the form of a service. So that's like a hospitality. So an example of it may be you're doing a medical treatment for someone, donation is coming. Transportation, they are doing a transport, they're allowing you places to stay, etc. Now foreign source is either giving in India foreign hospitality or foreign contribution. Now foreign source means anything which is incorporated abroad, whether a foreign company, foreign corporation, multinational, foreign trade union, foreign trust, foreign society, foreign citizen, foreign government, foreign any other government. Clear till here? Next, political parties are those who are registered with the Election Commission of India. Now this is important, very very important, past exam question. Okay, it's a past exam question as well. Prohibition to accept foreign contribution. So the following persons are specifically prohibited from accepting foreign contribution. These people, you cannot give donation to these people, and they've added one more word to the amendment, that is a public servant. Can you see this? We had seen in that under section 3(1), public servant is also within the ambit who cannot take contribution from others. So ये सारे लोग are prohibited from taking foreign contribution. So anyone who is a public servant, who is standing up a candidate for election, a member of the legislature, a judge, a political party who is having a political nature, a news channel, columnist, cartoonist, editor, etc. So all these people cannot take donations from abroad, and the reason is to protect the integrity and sovereignty of India. So they are prohibited. Next, if you go to see persons to whom section 3 does not apply. Now this is also exceptions. They can take foreign contribution. The reason is it is a very normal thing. Okay, a student getting a scholarship, so they are not coming under section 3. Or received from a relative has given a gift in India, that is okay. You're getting salary, so salary is not a donation, na? You're working hard. Agent, that's also business activity, so it's not going to come there. Then in the course of internal trade, any payment made in internal trade will not come here. A gift which is within the limit as specified by the central government, and any remittance received in the ordinary business through an official channel. So all these things can be received. It will not fall within the prohibition list. Next, restriction. Now earlier we did section number 3 we did was restriction on foreign contribution for all those people. Same way as they can't receive goods, they can't receive services also. Services are given under section 6. So the following are prohibited. Now similar people will be there. Any public servant, your legislature, political party, judge, servant, etc. They cannot give them hospitality. So sometimes what happens, they give, if I have a cruise company, to a judge I will give cruise, you'll free. Now this is not allowed because it can affect his judgment and it will affect people's confidence in his services. So restriction is there important. Now only one exception is there where you can do. So it's important. It's a past exam question also. If a judge or any person has gone abroad and he got a medical emergency, so that time we will not say it is prohibited. We will say you aap de do usko, give him some medical treatment, give it's hospitality, right? Even if he didn't have money, give him the treatment. You are saving the life. But moment he is become fine, he has to inform the government. So it is not necessary to obtain permission. So if any of this has to be done, you require prior permission of the central government. They are saying prior permission of central government is not needed if you are giving a medical aid on account of sudden illness. If you know, there is one actor, one singer, can you put in the chat box who it is? He had a live performance, very young, and suddenly he passed away. So can you put in the chat box who was that? I just want to see your general knowledge. So recently there was a singer, he did his performance and suddenly he got a cardiac arrest and he's passed away. Now same way, if a judge or some person, politician has gone abroad and suddenly he gets a medical emergency, so we will not say pehle jao, take approval of the government and come. So they don't require approval, he can quickly go. Moving ahead, then section 6 is also done. Now section 7, prohibit to transfer the contribution to any other person. So if contribution is given to you, only you can use it, you cannot transfer it to someone else. Next, power of the central government to prohibit receipt of foreign contribution. So these all 3 points are there. First 3 points are about foreign contribution and the next KK, yes, correct. And the next 3 are foreign hospitality. Foreign hospitality. So all the 3 points are same. First 3 is for foreign contribution. Next is for foreign hospitality. The central government has a power to prohibit the receipt of foreign contribution in certain cases. The central government has been empowered to prohibit the accepting of foreign contribution. So you can prohibit accepting. Then they can prohibit, they can say certain things that you require prior approval, and some they can say that you have to furnish information. Similarly, all the 3 points, that either we can prohibit, we can say put it under the approval route, you take our approval, or some we can say give us information. Same way, foreign hospitality, we will say we can prohibit, we can ask you to take prior permission, or we can say that you furnish information. This is section number 9. All I want you to remember is section number 3 and section number 6. Section number 3 is for whom is prohibited. So now if we just quickly go to the sections here. So that is it for foreign contribution. Now pay attention to that. Here. So section number 3 I want you to remember. Section number 3 is prohibition of foreign contribution by certain persons. Then they have said there is an exception also to whom all it is allowed. This is the most important from exam point of view. Section number 6 is about foreign hospitality. It is similar. Section 3 and section 6 is same. This is for foreign hospitality. This is for foreign contribution. Okay. Transfer is not allowed. You can utilize and tell the government. You can even certain companies can get registered and get a license. Here we are going to do that also. Just a sec. In this, if you go to see section 9, okay, section 11. Okay, now no person having a definite cultural, economic, educational, religious, social program shall accept foreign contribution unless he obtains a certificate from the central government. Now, central government can give a certificate. Means what? Being human wants to take any cultural program is being conducted and you want to take foreign contribution, foreign donation. You cannot do unless you've taken the approval of central government. Okay. That is it. And all the foreign contribution has to come through a genuine bank for these NGOs. A separate account will be opened for FCRA account and you have to disclose all the way you are spending the foreign contributions and donation. So that is it. We are done with the foreign contribution chapter. Now we will start with the consumer protection. Now we'll be starting with the consumer. Which chapter number is there in the module? So we'll be starting with lesson number 13, the Consumer Protection Act. And there is a very important amendment with respect to consumer protection. Okay, with respect to consumer protection also is there in the amendment. So there is a important amendment for Consumer Protection Act 2019. We'll be starting that. Where is my notes? So we will be starting with the Consumer Protection Act 2019. So we'll take a quick break, a short break before I start the chapter. Whenever I give a break, it is a break for me, not for you. You have to finish the chapter revision. So if I give you, I finished Foreign Contribution Act, you quickly go and finish that act. Okay, I finished big chapters today, which have very high weightage. Okay, so Consumer Protection Act we'll be doing. I'll take a quick break of 15 minutes. And this will be the last chapter of the day. We meet in 15 minutes and that time we'll be done with the amendments also. Till here it is clear? All good? These are all big chapters that I am completing. Really big. In the exam we'll see the weightage of that, how much it is. So even the liberalization scheme, if you've done FEMA, liberalization scheme will also get done automatically. We've done FEMA, we've done this chapter also, we did Foreign Contribution Regulation Act. Top 3 chapters I've done, and another chapter I'm doing because of I did this Competition Act also, 25 marks, and now I'm doing Consumer Protection Act. It has 35 marks, okay? Okay, I will take more chapters, but which one do you want me to take? You will also require time. Now, these are all big chapters I'm taking. I can take more chapters, smaller chapters, but these are really big, massive chapters which I'm taking. I will take more chapters that are saying I will take, okay? So, we'll just take a quick break and we'll finish this 2019 chapter. I'll finish your essential commodity and your this chapter. Which one do you want? And I'll take after this. I will take small chapters. Do you want me to take money laundering? Do you want me to take essential commodities or legal metrology? Quickly, I'm giving you the options. Any specific chapter, high weightage chapter you want me to take? You all can keep putting in the chat box. I'll read it up. If I can take it, I will take it up. Okay. RERA is there. TOPA or NBFC. Okay. Any other recommendation? Which chapter do you want? You are ready to spend more time. Okay, good. Very, very happy. Okay. Anyone else? What is Essential Commodities Act? Okay. I can take essentials. Small, chotu sa chapter. It's 2 marks only, but I'll take it up. Anything else? Any other recommendation chapters that you want? You can put it now. You have your chance. Put it. Maximum whichever chapters are there. I can take it. Both I can take. Legal metrology also quickly I'll finish. Essential commodities also I'll quickly finish. Waiting for you all to message in the chat box which chapter do you want me to take. ECA is also fine. Essential Commodities Act. Okay. Just waiting if anyone wants to message. Put in the chat box which chapter do you want. Nevin is saying transfer of property. Specific relief, Aparna. Any others? TOPA. TOPA is getting the maximum word. Pamela. Okay. Pamela I can take. Pamela will get over really quick. So what we'll do is, I will take these chapters. First, I will finish transfer of property, essential commodities. Okay. So I'm highlighting the chapters which I'll take. First, I'm finishing consumer protection. Then I'll finish essential commodities, legal metrology real fast. Then I will do money laundering really, really fast. You want RERA also. So I think I can finish either of them. You tell me TOPA or RERA. Which one do you all want? TOPA or RERA? Which one you all want me to take? But this will be fast revisions, okay? Really fast, because the ending chapters I go very fast. You want me to take TOPA or ERA? Quickly, I'm just waiting for your messages. TOPA. Chalo, I'll take. Okay, great. I want newer people also to message. Okay, so this will be TOPA it is. TOPA I'll be taking, okay? So I will take a short break. You all also can take a short break and come, and then we'll start with Consumer Protection Act. Okay? It will be a very, very fast revision. So be with me. Keep your modules with you. I'm doing from the module. Okay? I'm doing from the module. Keep your this with you. Okay. So we return back in 15 minutes. Call your friends also if they want to Consumer Protection Act 2019 revision. Okay. So we meet at 9:45. So we meet at 9:45 p.m. Get your book and pen. I will be giving you the sections. From there only it will come 110%. Okay. So I will be covering the entire thing. So I'll see you all quickly. You all can also take a break, but keep yourself online. Get 1-2 people with you, your friends. Okay, who need help. Done. See you all in 15 minutes. Okay, great. Can you all hear me? If you can quickly give me a confirmation, you can move ahead. If I'm audible to you all. Am I audible to you all? Just put in the chat box. We'll quickly start and finish Consumer Protection Act. Just waiting for your confirmation. Am I audible to you all? Yes. Audible. So what you all need to do is keep your module in front of you. I will be giving you all certain markings. From there only it will come, and I will give you all certain section numbers also, which you all have to quote in the exam. Okay. So let's quickly begin. Hi. So we'll be starting your Consumer Protection Act 2019. Now this Consumer Protection Act 1986 was there. It has been repealed, and now we have the new act, which is 2019. Now this has introduced newer concepts. The most important is your product liability, which we will see towards the end. It is very important and even can come in your examination. They have also introduced a concept called as Consumer Protection Authority, which also is very important and expected to come in your exam. And very important amendment. Okay, I'm taking you to the amendment first. Take a book and listen to it loud and clear. If in your book there is something given that the district forum has up till 1 CR, then it is up till 10 CR, and then about 10 CR is this. This has now been repealed. Okay, this has been repealed, or I can say replaced. Do you all know the amendment? Yes or no? Did you all know the amendment? Just put in the chat box. This is the important amendment that I'm talking about. Did you all know the amendment? Yes or no? Just put in the chat box. Did you all know that there is this big major amendment in the chat box? So the amendment is that the limits for all the three councils have been changed. All the three council limits have been changed. For the district forum, matters up to 50 lakhs goes up to the district forum. Matters up to above 50 lakhs but up to 2 crores go to the state forum, and matters which are exceeding 2 crores go to the national forum. Now what happened is, earlier the matters used to go up till 1 CR used to go to the state. Yes. So it used to go to the state. So what happened is, the state government, there were so many matters which were coming. There were so many matters that were coming to the state government, because the limit was 1 CR. The district forum, it was coming till 1 CR. All the matters. So district forum said, I cannot handle this overloading of cases. Please reduce the cases. So what happened is, the pecuniary jurisdiction. So as per the center notified the Consumer Protection Jurisdiction Rules 2021. It said it revised the pecuniary jurisdiction for the consumer courts. Up to 50 lakhs matter will now go to the district commission. Matters above 50 lakhs up to 2 crores will go to the state commission, and above 2 crores will go to the national commission. So this is the important amendment. Understand, earlier this was 1 CR. Now 1 CR means so many matters are there within 1 CR. All used to go to the district only. So there was overburdening of cases, and very few matters went to state and national. So then they said, let's make it little bit normal. So this will be the limit. You can remember, from 0 to 50 lakhs, then 50 to 2 CR, and then more than 2 CR. This will go to the district commission. From this range will go from above 50 lakhs to 2 CR will go to the state commission, and from above this will go to the national commission. Clear till here? Please take a note of this important amendment. Don't end up writing a wrong limit for the courts. Then they have also introduced a concept of mediation in your Consumer Protection Act 2019 and your councils. So let's begin with the chapter. So the Consumer Protection Act, consumer means a person who buys goods or avails a service for consideration. So a consumer, the meaning of the term consumer is a person who buys goods or services for consideration. It does not include a person who is obtains the goods for free for reselling or who is using for commercial purpose. The Consumer Protection Bill was passed in the Lok Sabha in July 8th. It was passed in the Lok Sabha on 30th July 2019 and was passed in the Rajya Sabha on 6th August. Now with the Consumer Protection Act 2019, they have also given you all these following rules. Now I want you all to take a break, stop whatever you are doing, take a screenshot of this. I want you to put this in the examination. Now your Consumer Protection Act has around 107 sections. 107 sections only. Doesn't have too many sections, only 107 sections. Okay. Now from here, chapter will be framed, the answer questions will be framed from here only. Consumer Protection Council is your chapter 3 to 9. What do the Consumer Protection Councils do? Can you all put in the chat box, what do the Consumer Protection Councils do? One word, what is their main job? Put in the chat box, Consumer Protection Councils, chapter number 2, section 3 to 9. They are I want one word from your end. What do you think it is? So it is an advisory body. It gives advice to the consumers. It gives them Jago Grahak Jago, takes a lot of awareness programs. Okay, helps the consumers. Next, section 10 to 27. Very important. Your Central Consumer Protection Authority. I want you all to put in the chat box in one word, what does the Central Consumer Protection Authority do? What is the main function? So this is an enforcing agency. So it is like how we have SEBI. So this is a new agency made. So they enforce. So they can search, seize, arrest, take on investigation. So this has executive powers. So they have executive powers like your SEBI for share market, RBI for banks. Similarly, for consumer related matters, Consumer Protection Authority is there. So this authority monitors and sees if there is any unfair trade practice in the market. On complaints they can receive, they can do investigation, inquiry, search, seizure, arrest, everything they can do. Clear? Very good. What is the one word for Consumer Dispute Redressal Commission? One word for Consumer Dispute Redressal Commission. What does it do? What does it do? I want you all put something in the chat box quickly. From whatever knowledge you have, put in the chat box. Very good. So this is a court, consumer court. In Consumer Redressal Commissions are your district commission, state commission, national commission. The sections are 28 to 73. Now tell me one thing, do you encourage everybody to go to the court? Do you encourage everyone to go to the court and settle the matter? Answer is no. So the government has made something called as a mediation. Mediation is to settle out of court for settlement purposes. The parties can have arbitration kind of a thing and settle it. Product liability. Very good response. Now product liability. Now what is this concept of product liability? Section number 2 to section number 87. So product liability is, remember of certain products which have blast, like there was a Samsung Galaxy Note which had blasted. It had caused injury to many people. Sometimes the airbags did not open in the car in the accident and there was injury. So product liability is now a good concept, that whenever there is a damage, okay, or loss to the consumer or harm to the consumer due to the product, sometimes we have used some cream and there is some side effects, so then they will be liable. Now in that they have said what is the liability of a manufacturer, product seller, what are their liabilities. Then offenses and penalty and miscellaneous. Very, very good. Okay. So at least now you can give me a confirmation that you will be able to quote these sections, because question will come from here only. From chapter 2, chapter 3, chapter 4, chapter 5, chapter 6. From here only the question will come. You will be able to quote in the exam, yes or no. Okay. Now let's begin quickly. Now in the examination, if you notice, from Consumer Protection Act, they ask certain section, they ask certain case laws. Situational case laws they will ask. For example, they will say that XYZ case law they will ask. For example, they will say there is a small kid, he drowned in the swimming pool when the school had taken him. Is the school guilty of negligence, deficiency in service? Yes or no? Then they will say that give you different examples and ask whether there is compensation can be given or no. So will compensation be given to the parents? Yes or no? So this is the kind of question that will come, situational questions for consumer protection. So for that you have to be well prepared to write the section number. So you will write the section number. For consumer, definition is section 2 subsection 7. We all know the definition of consumer is a person who buys the goods or avails the service for consideration, includes the beneficiary, but does not include use for commercial purpose. Okay, section is fine, but remember the section number. It's going to come in your exam. Okay, this is a short exam question. Then for defect, you will say that whether you are saying compensation will given or no. So you have to say that it constitutes a defect under section 210 or it constitutes a deficiency under section 211, and then you will say compensation will be given or no. Moving ahead to definition of consumer, section 2 subsection 7. I believe you must be knowing consumer is a person who buys any goods, includes the beneficiary, okay, but does not include a person who uses it for resale or for commercial purpose. Then hires, now again this is for buys goods, this is for takes any service for consideration and includes the beneficiary but does not include a person who is taken for commercial purpose. However, expression for commercial purpose does not include when you're using it for self-employment. When you're using the goods for the purpose of livelihood for self-employment, it is not covered. So they have given you cases now in this. When I'm using the goods, मैं goods use कर रहा हूँ for my livelihood, then it is not treated as commercial purpose. Everybody works for livelihood, so it is considered as self-employment. They have given you two case laws. Anyone can tell me what is the name of that case law? You have to quote this in the exam. It has come in situational question also. So Lakshmi Engineering Works versus PSG Institute. Learn the case law. You can quote in the exam that working for commercial purpose. So this was a lady. She was widow. She was working for. She had a Xerox machine and she was using it for livelihood. It was held that it is not commercial purpose. She is a consumer. Same way, Bhupendra Jung versus regional manager. It was said that he was a farmer using it as a tractor for his own livelihood. Was not a consumer. Okay. Then again, Now, I believe your SEBI paper was a little difficult. Yes or no? Can you file a case on ICSI that why did you ask outside the module? So there was a case where the student who appeared for the examination said that the paper checking was not proper. That it was not corrected properly and asked sued the university for compensation. Is he a consumer and will it succeed or no? So it was held that the university in conducting examination, evaluating answer sheets and publishing the result was not performing any service for consideration, and a candidate who appeared for examination cannot be considered as a consumer. Okay. Then very, very, very important. Okay. Now shares are movable property. Shares are movable property. When a company does not allot on time, can it say that there is a deficiency in service? So Morgan Stanley mutual funds versus Karthik Das. The Supreme Court held that any application for allotment of shares cannot considered to be goods. It is after allotment rights may arise as per the Articles of Association. At the stage of application, there is no purchase of goods, and again the purchaser cannot be a hirer of service. Understand, this is exam importance. First, as per section 44, okay, when you read, you will come to know shares are movable property. Movable property. Shares are movable property. Till the shares are not allotted to you, you don't have movable property, you don't have goods. So therefore you cannot file a case. So a person who just filed at the application stage, he's not got the goods, he's not a consumer. I hope this is clear. Then next, if you go complainant, very very simple. If I say complaint means an allegation in writing made by the complainant seeking for relief, saying that what all complaint you can give, that the goods were not proper, that the services goods defect in goods, deficiency in service, unfair trade practice, charging above the MRP, giving false representation, all these things, misleading advertisement, and there is a product this a claim for product liability action lies against this. So this is a new point. So that's a complaint. Moving ahead, who all is a complainant? Who can complain? Consumer can complain, voluntary institution can complain, government can complain. Many consumers coming together in same interest. Sometimes what happened, we've seen in building, all the tenants come together. Since they all have a common interest, they will file a case on the builder only. So that is all the consumers coming together. Legal heir is also a consumer and a guardian of a minor. So these are the definition of complaint. Defect in goods. Now remember, defect in goods, you will remember whenever there is a FECE. So a fault, imperfection, shortcoming or inadequacy in the quality, quantity, purity, potency of the goods which were required to be maintained and not maintained is considered to be defect in goods. So if you get a broken toy, okay, so the voice is breaking. Is my voice unclear, or I can move ahead? Is my voice clear, or I can move ahead? Okay. Now deficiency. Deficiency again means any FECE in which was in any quality, quantity, purity which was required to be maintained and it was not maintained. Okay. And includes act of negligence by such a person which causes loss to the consumer, deliberate withholding of any information by such person. Now understand what is deficiency. Whenever there is a FISI, FISI, fault, imperfection, shortcoming or inadequacy in the quality, quantity, purity, standard of the goods which were of the service which was required to be maintained and it was not maintained. Next, consumer rights. So remember the word riches, RICHES. So right to be R is for right to redressal, I is for right to be informed, C is for right to choice, right to be heard, right for awareness, right to be protected against hazardous products, and right to assurance and safety. Okay, so these are all your rights of the consumers. Now coming to this endorsement. Nowadays we see all these celebrities endorsing. Endorsing means what? Whenever they drink, they say very nice. They give a opinion and encourage others to earn. So they can be considered to be endorsers. Endorsement in relation to an advertisement means a message, a depiction of the name, signature, likeness, or any other identifiable personal characteristics which makes the consumer to believe its reflection, opinion, finding, experience, or the person making such endorsement. So when they say it is one of the best, so it assumes that I'm endorsing it because my opinion is being seen. Express warranty. Express means clear warranty. Any material, statement, affirmation of fact, promise or description relating to the product, service, warranting that it conforms to such material, statement, affirmation, promise, description and includes any sample or model. Means any material, statement, affirmation of fact relating to a product that it conforms to a certain level. For example, if I say it is a ISI mark, or if I say that it is a 2 years, it is going to run properly. So this is what you're doing. You're making a statement, a affirmation, a promise, a description relating to goods or service that it confirms that वो रहेगा बराबर goods. Okay, then we see harm means you got a damage to your property, your health, your mental agony or loss of services that is there. Okay, misleading advertisements. So again, when you misleading advertisement is in relation to any product or service means an advertisement which is falsely describes such a product, which falsely gives a false guarantee, which conveys a representation which would constitute an unfair practice and deliberate conceals important information. This is all misleading advertisement. What is misleading advertisement? It falsely describes such a product. This is the number one, the best, it is very very good. So I am making a false description. Gives a false guarantee. Don't worry, this helmet will not break. I give a false guarantee. Conveys a representation. If so, I say that it has been ISI mark is there, or deliberately conceals important information is a misleading advertisement. Okay. Then one comes contract of service and contract for service. Very very simple. Supreme Court judgment in Indian Merchants Association versus VP Shanta. So important case law you can remember. Very simple. Contract of service is a contract of employment where there is an employer-employee relationship. So there exists an employer-employee relationship where the employee has to work under the direction of the employer. He is under direct control. So in such cases, in contract of service, the principal will be held liable for whatever it is there. I am working for my principal. Employee is bound to work as per the direction of the employer. Contract for service. So many times professionals like us, company secretaries, chartered accountant, we all come here. We are not under employment. We don't have to be necessarily under employment. We are under advice. We give advisory to you. In that, employer doesn't tell us what to do. We tell the employer what to do. So their employer-employee relationship does not exist. Day-to-day control is not there. I am at the discretion to give my opinion. I am free. I will give a audit opinion as and when I like. I am not under you. Okay. If they ask you spurious goods, okay, such goods which are falsely claimed to be genuine. Unfair contract. So again, which gives excessive, where you take unfair contract means a contract between the dealer and the consumer, where it requires excess security deposits, imposes excessive penalty, refuses to accept early payment of debt, entailing a party to the contract to terminate such contract unilaterally, that you cancel the contract, permitting one party to assign the contract to the detriment of the other party, and imposing on the consumer unreasonable charge or condition. So whenever you do anything wrong, it is considered to be unfair contract. Unfair trade practice, again, making a false representation, false, misleading. Everywhere it's false, misleading only. Okay, misleads, etc. will be treated as a. So you give a false statement with respect to the quality, quantity, purity, standard, with respect to your build, with respect to its sponsorship, with respect to its working, etc. will be treated as a unfair trade practice. Now, Consumer Protection Council. Now till here we were just doing the definitions. Now we're seeing the Consumer Protection Council. What does the Consumer Protection Council do? They give advice, they assist. So if this comes in your exam, you can write section 3 to 10. The interests of the consumers are sought to be promoted and protected with these councils. These councils have been established for the purpose of spreading consumer awareness and to protect and preserve the rights of the consumers. Now, consumer councils are at 3 levels. One is at the district level, other one is at the state level, and third is at the national level, central level. Now, Consumer Protection Council, all will have one you do, all three sub ho jayega. Now, if you go to see section 3, the central government empowers to establish central councils. This council shall meet, at least one meeting of the council shall be held every year. The council shall meet at such time and place as the chairman deems fit. Now this was central council. This central council will be set up by the central government. And the object of the central council is to render advice on promotion and protection of the rights. Okay, consumer rights. So there are all these councils' duties what? For protection, promotion and protection of the consumer rights. Now we are doing the state. Everything will remain the same, only from center it will be the state. State government has established this. Now this council will be an advisory. Okay, they will have as 2 meetings in a year, and the object is promotion and protection of the consumer rights. Same way here also in district, it has the state government is empowered to establish district. This work is to do advisory. They will meet at least 2 meetings in a year, and their job is for advice on promotion and protection of the consumer rights. Moving ahead to the most important section 10 to section number 27, the Central Consumer Protection Authority. Now the central government will set up the CCPA to promote and protect and enforce the rights of the consumers, to regulate matters relating to consumer rights, will have a investigation wing, very very important, and a director general that may conduct inquiry. Section 10 to 27 deals with the Consumer Protection Council. So it has an investigation wing, just like how we have SEBI, it can investigate. So the central government has established a Central Protection Authority to investigate and regulate the matters respect to the violation of the consumer rights, unfair trade practice, false misleading statements which are prejudicial, which are harmful to the interest of the public consumer, and to protect and promote the rights of the consumers. Very, very important, this council will have a investigation wing. The investigation wing will be headed by the Director General. He can conduct inquiries and investigations made by the Director General shall be submitted to the central authority. So whatever the Director General will do, it will be told to the central authority. Very, very important, what are the powers and functions of the central authority? So they have a, first they will give you empowers. Two, so what all powers do they have? They have the powers to protect, promote, enforce the rights of the consumers, prevent unfair trade practice, ensure that there is no false or misleading advertisement, and ensure that no person takes part in publication of any advertisement which is false or misleading. Now this is power of the central authority to recall the goods. So sometimes when goods have become damaged which are harmful, then they will call it back. So once there was this Vento cars, the diesel engines were not working properly, or we have seen electric scooters of Ola, it was catching fire, so they will call it back. So as per section 20, where the central authority is satisfied on the basis of the investigation that there is sufficient evidence to show that the consumer's rights and unfair trade practice by a person, it may pass such orders recalling the goods which are dangerous, harmful, unsafe, reimbursement of the price, and discontinuation of the practice. They have a power to search and seize. Now this is a case can also be done on a Director General if he files a vexatious search. Vexatious means malified search if they do. So then the officer, there will be a penalty on the officer if he harasses any company just to remove money. He has done a false raid. Okay, now appeals. Very, very important. If a person, a order has been passed by the CCPA, the Central Council Protection Authority, okay, then or central authority, from the central authority, appeal will go directly to the National Commission within a period of 30 days from the order. Now next is the Consumer Dispute Redressal Commission, as we saw, state, district and national. I gave you the pecuniary limits. Remember, district up to 50 lakhs will go to the district, above 50 lakhs to 2 crores it will go to the state commission, and above that it will go to the national commission. Okay, so they can ask you write a short note on the redressal machinery under the Consumer Protection Act, or they will give you write about the three-tier Kasai Judicial Redressal Forum. So you will write about the three commissions that the state government will establish this state council. Okay, it will have jurisdiction for a matter up to whatever limit they have given. Then territorial, whatever matter is there within the district will come here. And all of that, one you do, all the other will be done. Okay, so even after this, they will say every state machinery will have a mediation cell where you can settle that up, and where the parties agree for settlement by mediation, give their own consent, the district commission shall within 5 days of the receipt of such consent relating to where mediation shall apply, consent, refer the matter for mediation. So where the parties agree for settlement, then immediately within 5 days it will be settled. In writing, the district commission shall within 5 days of the receipt of their consent refer the matter to mediation. Procedure for admission of a complaint, very, very simple. You will get the complaint copy, send the summons to the opposite side. The opposite side will come with its own written statement. Opportunity being heard will be given. If possible, it will be sent to mediation. If there is a product, okay, they can send that product to the laboratory if they need. Okay, on admission, they will proceed with the complaint. Where the complaint relates to any goods, the complaint copy will be given to the opposite side. If the opposite side on receipt of the complaint denies or fails to take any action to the representation within the given time, they'll proceed to settle the consumer dispute. Okay, so you can read it up. It's a small little procedure. And all these forums will have the same powers of a civil court for summoning, requiring affidavit, taking them on oath, etc. Now, findings of the district forum, they will have all the rights to remove the defect, replace the goods, return to the complainant the price, award compensation, remove the defects, discontinue the unfair trade practice, not to offer hazardous, withdraw the same, pay an amount as compensation for the product liability, etc. Appeal from the district will go to the state within 45 days, but you have to, whenever you're going in appeal, you have to deposit 50% of the amount. Then only you can go, then you go to the state. State also, the same points are there. And then national. Limitation period is within 2 years from the date when the cause of action arose. Very, very important. Section number 69. Means what? If the right was violated today, right is violated today, you have to go to the court, the consumer courts, within a span of 2 years. Within 2 years, you will go to the court and then file in the court, and then all those appeal provisions will apply. So, if today my rights are violated, I have to go to the court within 2 years. After 2 years, the court will not entertain. They say, why didn't you come in 2 years when your rights were violated that time? Then comes the concept of mediation. Mediation is settling the case mutually, settling it out of court. Every district, every forum, district, state and national forum will have a mediation cell. Okay, and mediation is a voluntary, partly friendly, cost effective tool. Mediation can prove to be effective tool for dispute. According to the Consumer Protection Act, a consumer mediation cell has to be attached with all the dispute resolution forums. Establishment of the consumer mediation cell, the state government shall establish these mediation cells attached to each district forum. They shall consist, every consumer mediation cell shall maintain a list of proper mediators, a list of the cases handled by them, recording of the proceedings, and every consumer mediation cell shall submit a quarterly report to the district forum. Then they will get proper empanel mediators who are having the required qualification, and they shall be appointed for a period of 5 years. The duty of the mediator to be disclose the fact. So they will have to say if they are personally connected or no. It's like a statement. So you can read it up, it's important. Then comes to product liability. Product liability is whenever a product has caused a loss or harm or injury to the consumer, then that company or the seller will have to pay it. Now, section 83 says a product liability action may be brought by the complainant against the manufacturer, or if it is service, then service provider, or a intermediary product seller also. Who is the liability of the product manufacturer? If there is a manufacturing defect, then the manufacturer will be held liable. Product is defective in design. There is a deviation from the manufacturing specification. The product does not conform to the express warranty. The product fails to contain adequate instruction regarding the usage of the goods, and warnings are not there properly. So in such case, you can make the product manufacturer liable. Liability of the service provider: if there is a deficiency in service, there is a negligence, withholding of information which has caused the harm, you have not disclosed certain things which because of that the loss was there. Services provider did not issue adequate warnings and did not conform to the express warranty. So these are common points. Then comes product sellers. Now product sellers are different from manufacturers. Manufacturers are those who have manufactured the product. Sellers are the ones who are intermediary, who are selling the manufactured goods. For example, I can import goods, they must be manufactured abroad and I sell it in India. So when can my liability be there? So this is also important. A product seller shall be held liable for product liability if he had control over the testing, manufacturing, he has altered the product, he has given an express warranty independent of the express warranty by the manufacturer. Independent means in extra of what the manufacturer said, I gave more. The product he has been sold, the identity of the product manufacturer is not known. So if you don't know who has made it, then the product seller will be held liable. He failed to exercise reasonable care in assembling, inspecting the goods. Now, very important, if you were the lawyer for this company who has caused loss to others, what defense can you take? So these are the defenses that you can take and you will be safe. Firstly, product liability action cannot be brought against the product seller if the product was misused, altered, modified. In product liability, the product manufacturer shall not be liable if, when he will not be liable, he had provided the warnings. He sold as a component to be used in another product and the necessary warning was given by him, were given by the product manufacturer to the purchaser, but the harm was caused to the complainant by the use of the end product. Now understand this, I'll give you an example. If I have sold a car battery, the manufacturer of the car used that battery, and then there was some explosion in the car. So what I will say ki boss, I did not sell car, I did not manufacture the car, I manufactured the product, the battery, which was used in the final product, and you got lost due to the final product. So then I will not be held liable. So that's what they're saying. The product was sold as a component, as a raw material, and loss was caused due to the end product. So I will not be held liable. The product was one which was legally meant to be used the supervision of an expert, under the supervision of an expert, but you did not use the expert. The complainant under the use of alcohol or drugs which has not been prescribed by the medical practitioner. So basically the complainant is complaining, but he was under drugs or he was having alcohol, and that is why he got a loss, and that is it. They give you the penalties. Okay, so I'll just show you how one example question. Okay, so Rubina was operated in the hospital under the control of the government, the free charge family planning, whether there is a deficiency in service. So always remember the section number, you have to quote correctly what you mean by goods and service. In the instant case, tubectomy is rendered under free of charge. So it will not fall within the ambit of service. So it was given free of charge and she fell ill. So it will not be held liable. Then few cases believe you must be knowing, and that is it. We are done with the chapter. Thank you so much. So we are done with this Consumer Protection Act also. Okay, 2019. Okay, so let's see. I will just do you want me or do you, thank you so much. Do you want me to take up any other chapter? Will you all be able to sit? I think I'll just take up chotu chapters like money laundering. Okay, so I think from all these chapters, I think money laundering still has more marks. Money laundering is there, it will come. So I'll take up money laundering, okay? More marks than the others. So let me take up money laundering. Transfer of property, how we finish? Very, very big. Too big chapter. So you must have studied somewhere, right? Transfer of property. So just be in our WhatsApp and Telegram groups. If there is any important chapter that I have, I'll put it up. Okay, which I couldn't take today, I'll put it up in the group. So please join the Telegram and the WhatsApp groups given in the description. So one more chapter I will take, whichever you all put, I will take it. Whatever, how, no matter how big you put it. Which chapter should I take? In the okay. You want me to take transfer of property? Will you all be able to sit? 8 marks chapter. Will you all be able to sit for the Transfer of Property Act? Yes or no? Or I'll take RERA. In more people to. Okay. TOPA, you all are saying. Let's see if there are more people ready to sit. No much this. Okay. Let me start with Essential Commodities Act. I'm starting with the Essential Commodities Act. Essential Commodities Act. I'm starting. Hello. Yes. Hello. Anything you have to say? Okay. So we'll start with the Essential Commodities Act. Quickly finished. We'll take a 15 minutes break. Okay. So 15 minutes break. Then we start with this chapter. Okay. Hi guys, am I audible to you all? So we'll quickly start. So I need you all to just put in the chat box if it's okay. So I'll quickly start with the Essential Commodities Act. I need you all to put in the chat box if it's okay. Okay, cool. So let's begin with the Essential Commodities Act. Now the object of the act. First, any act we do, we have to first understand what is the object of the act. So the Essential Commodities Act is an act by the Parliament which was established to ensure the delivery of certain essential commodities so we could prevent it from hoarding and black marketing. The objective of the act is to control the production, supply and distribution of certain essential commodities. So in short, certain essential commodities होती है जो हमारे तुम्हारे और मेरे day to day use के लिए होती है. So goods which are of day to day importance, government controls those. So those kinds of goods, the pricing is controlled, the production is controlled, the distribution is controlled. You cannot do artificial shortage of such goods. So Essential Commodities Act 1955 is to ensure that there is easy availability of essential commodities to protect the consumers from exploitation by unscrupulous traders. So all these words you have to learn and write. For the regulation and control of production, distribution, supply, which are declared as essential. For the purpose is to maintain proper supplies, to ensure equitable distribution, and to secure it at reasonable fair prices. Now, the definition of the essential commodities. Section 2A of the Act states that an essential commodity means a commodity specified in this schedule. So we'll have to go to see what all is given in the schedule. So the schedule contains 9 commodities such as your, okay, they have given you 9 commodities out here. Okay, these are your essential commodities to which this act applies. Drugs, certain kinds of drugs which comes under drugs and cosmetics acts, your medicines come here. Fertilizers, foodstuff, yarn, petroleum products, raw jute, food crops, cattle fodder, jute seeds, cotton seed, face mask. Now this all was added after the amendment. In COVID-19, even face mask and hand sanitizers have been considered to be essential commodities. So now you cannot hold it, that is create artificial shortage. You cannot charge beyond a certain price for these goods. These are essential commodities. Now in Samuel versus Union of India, it was held that tea is not foodstuff, because we saw essential commodities, they have covered that foodstuff is an essential commodity, Here it has been held that tea is not a foodstuff. Common sense. Tea you do not necessarily need. Tea you do not eat. You drink tea. It's a beverage. Tea leaves are different from tea. So foodstuffs does not include tea. Tea leaves are not eaten. Tea is a beverage. Tea neither nourishes the body nor sustains nor promotes its growth. It does not have any nutritional value. Okay, in common parlance, one who who has taken tea would not say that they have eaten food. Thus, tea is not foodstuff. If it is not foodstuff, it's not an essential commodity. If it is not the essential commodity, it does not come under the government's control. Then certain definition have been given. Again, just sugar, because foodstuff, sugar, they have told you. Now what is sugar? Sugar means any form of sugar containing more than 19% of sucrose, including sugar, khandari sugar, bura sugar, crushed sugar, any sugar in crystalline or powdered form. Now these are all different forms of sugar. Sugar in process in vacuum, pan, sugar factory, or raw pan or raw sugar. So all these is definition of sugar. Now, powers of the central government. Now, section 3 is important. Section 3 says the power of the central government to control the production, supply and distribution of essential commodities. Now, which government? It's a central act. The central government has a power to control the production, supply and distribution of essential commodities. Why are they doing it? So that you can maintain that it is for maintaining supplies. Whenever it is needed, we should have it for securing equitable distribution and to ensure that the goods, essential goods, are available for the defense of India. Now, when the central government, what kind of orders they can pass? So, central government, if I am the central government, I can tell the people who are dealing with this essential goods, I can control where it will be stored, I can control its price, I can control its uh, pricing, I can control its distribution, I can control uh, who it will be sold to. I can seize the goods. So the orders of the central government could be to regulate by license, so giving licenses, permissions for production, manufacture of any essential commodity, the storage, transport, distribution, disposal, acquisition of any essential commodity, prohibit the withholding of essential commodity, for requiring any person holding any commodity to release those goods to sell. We can order anyone to sell it. Okay, we can regulate any kind of transaction which is going to be detrimental or harmful to public interest. We can enter, search and examine places where essential commodities are there, and we can even seize it. Now section 3, subsection 3 talks about the fixation of price when these essential goods are sold to the government. Essential commodities are those day-to-day necessary goods for which we cannot allow the pricing to go very high or to be artificial shortage. So the government comes to control. Government can buy these goods from dealers. For example, face masks the government can buy for distribution. Hand sanitizers they can buy. Food stuff they can buy to give to the poor. They can even take food, whatever it is, food stuff to give to for the army, etc. So the government many times are buyers. Now you put in the chat box, you think when the government is buying, they will pay the market price? Always they will pay the market price to the dealers, or they will buy at cheaper price. So sometimes obviously the government, they can deal with the market price, they can buy at the market price, but it is not normal. Sometimes there can be an agreement between both of them. Okay, fine, market price is so much, I will give you at this price. So agreed price is what both of them have agreed. Sometimes the goods are of essential commodity, essential need, there is a urgent necessity, and the dealer is saying I will not give, I am not agreeing also, I will give at market price only, I am not agreeing. So in such cases, the government will fix the price. This is controlled price. Controlled price means what? They will control the price and tell what it is. The dealer will have to listen. Now, fixing of price of essential commodities during emergency. Now, when there is an emergency, means there must be emergency will get over also. So the maximum time period is also given. It shall be in force for 3 months only. So during that time, the government can ask the person to meet any emergency provision and be resorted to meet a situation arising at a particular locality. It empowers the central government to direct the price at which the foodstuff will be sold to general public, and the seller shall be paid the price in the same manner as section 32F. What is 32F? What is 32F? Same thing. What is 32F? Can anyone tell me in the chat box? This is it, section 32F. Market. So when we are buying, we will give either market price or not the market price, agreed price. If not the agreed price, then we will decide what price it is to be given. Then again, payment of procurement of price for food grains and edible oil, not very important. Again, same 2F price can be decided, controlled price, whenever we are buying, controlled price. So the Essential Commodities Act amendment inserted section 3B in substitution of the existing provision for payment of procurement price of food grains, edible oil, oilseeds as specified by the government with the approval of the central government. Any person is required in terms of an order under section 2F to sell to the government. तो अगर कभी भी एक ऑर्डर आया है कि आपको गवर्नमेंट को बेच देना, यू हैव टू सेल इट टू द गवर्नमेंट, एनी फूड ग्रेन्स, edible oil, oil seed to which no notification has been issued, then the procurement price shall be paid irrespective of the subsection 3 giving regard to the following fact. So when the government is buying all these edible oils, then these things will be seen. We will see the control price, price fixed by the government as the control price, the general crop prospects, what are the what the person would have bought, what would have we got with this money, the need for making such a grade or variety of food grains available at reasonable prices to the consumers, the vulnerable sections of the consumers, the recommendation of the Agricultural Price Commission with respect to these things. Now this is not important, but simple thing what they are saying. We will see what is the control price, we will look at how much this crop would have got, what are the prospects, what is the recommendation given by the Agricultural Price Commission. Now fixing of price for sugar to be paid to the producer. Similar thing, minimum price, manufacturing cost of sugar, duty or tax, securing a reasonable return on the capital employed. So whenever we require a person to sell sugar to the government, the producer shall be paid such price for the sugar as the central government may by order determine having regard to. तो हम लोग देखेंगे कि इसको कितना प्राइस देना है शुगर का. So we will see, keeping all these factors in mind, what is the minimum price, what is the cost of sugar, what is the duty and taxes that he must have paid, and what is the reasonable return we should give him. Now confiscation of essential commodities. Confiscation of essential commodities. Seizure and confiscation. There is a difference between seizure and confiscation. Can you tell me what comes first? Seizure comes first. Okay, so seizure comes first and then comes confiscation. So seizure means what? Sometimes there is a search. In search, we had reasons to believe that you had done something wrong. So we will seize the goods, take it out of your possession and keep it in the government possession. Then the case will go on. फिर केस चलेगा. अगर केस में तुम जीत गए, if you win in the case, it will be given back to you. But if in the case you lost the case, then it will be confiscated. Confiscation is ownership will change. In seizure, the ownership doesn't change. Okay, so if we see the difference between search and seizure, this is a past exam question also. So in seizure and confiscation, in seizure, what happens? The goods are taken out of your possession, so the possession changes. Possession changes from the dealer's possession to the government's possession. In confiscation, the ownership only changes. Ownership changes. Okay, so you take it from the person, the dealer, and you say you lost the case, you were wrong, these are all counterfeit goods, you have wrongly done, and you will do. So this seizure is on prima facie evidence. On prima facie evidence. On the first look, पहले देखेंगे गलती है तुम्हारी, इसके लिए सीज किया है, फिर कोर्ट में केस चलेगा, और after all the arguments you lost the case, then confiscation, then it will be permanently confiscated. So this is after detailed evidence. Detailed evidence. Then seizure comes first. This is the last stage. Last stage. This is the first stage. First it will be seized. In seizing, you may get back the goods. May get back goods if you win the case. But in confiscation, you lose ownership in goods. Ownership in goods. Okay. In seizure, you are the owner. In confiscation, central government is the owner. Okay. Now, issue of show cause notice before confiscation. Obviously, they will give you a show cause notice. Opportunity of being heard. We will hear you out only then. Confiscation order will be done. Once confiscation order is done, any aggrieved person may appeal to the state government within 1 month from the date of passing the order. Then comes offences. Cognizable offence. Now, what do you mean by cognizance of offence? Cognizance means any offence done for the Essential Commodities Act. It is a very big thing. Shall be treated as cognizable and non-bailable. Cognizable means a serious offence and therefore it is non-bailable. Now coming to mens rea. Now this is also a past exam question. A past exam question. In this it is held, what do you mean by mens rea and whether mens rea is needed in essential commodities. In Natulal versus State of Madhya Pradesh, it was held that mens rea is an ingredient or guilty mind is an ingredient of an offence punishable under the Essential Commodities Act. So in Natulal it was held that mens rea is an essential ingredient for punishable under the Essential Commodities Act. That means the offence should be intentional. In other words, if the dealers did believe bona fide that he could store the goods without infringing any order, there would be no contravention of the act. In Hari Prasad Rao versus state, it was held that mens rea is an essential ingredient. Now, what does it mean? Let's understand. We are making it a criminal offence or no? Cognizable and non-bailable. So, mens rea should be required. Now, mens rea is required. You should have the intention to do the crime. Then comes what is the meaning of culpable mental state. Culpable mental state. It is the same concept like mens rea. Okay. So culpable means you had that intention, bad intention. Refers to the state of mind. Mental state means what? It's a state of mind of an individual while committing a crime. It would be culpable mental state if he does with negligence, recklessness, knowledge or purpose. The culpable mental state is synonymous with mens rea, means the same है mens rea के जैसे. Section 10C provides that a presumption of culpable mental state. हम लोग presume करेंगे, we will assume, हम लोग मान लेंगे कि आपके पास में state था which includes intention, motive of doing the crime. It is provided that in any prosecution of an offence which requires a culpable mental state on the part of the accused, the court will presume the existence of mental state. Of course, it is open to the accused to prove that he had no such state with respect to the act committed by him. So it will be presumed in some of the offences which are very serious. It is always presumed that you have the culpable mental state. तुम्हारा intention था. It is on the opposite side to prove that he is not guilty. Normally, we always believe that he is innocent till he is guilty. But there are certain offences when caught, it will be presumed that you have done and you have to prove. So you have assumed that you have done it and you have the burden of proof of innocence is on you. तुम्हें prove करना है. अगर तुम prove नहीं कर पाए तो तुम गलत हो. I'll give you example. Example is terrorism. If you are caught and government has booked you under the Terrorism Act, you are presumed to have it. You have to prove you are innocent. Clear? So that is culpable mental state. So that is it. We are done with this chapter also. So that is it. We have completed many chapters for now. Okay, so we have completed your FEMA. We've completed 12 mark chapter. We've completed FCRA. We've completed even if you see liberalized remittance scheme also will be get completed only because it is just one thing, $250,000. So if I go to LRS scheme, if I go into liberalization, privatization and globalization. So up till $250,000 you can transfer abroad. Beyond that, if you do, you require RBI approval. For companies, it's different. I have done it in FEMA only. So LRS also is get over. Do FEMA and LRS together. That is also over. Okay. So we have also completed LRS scheme. Okay. So we have done liberalization, privatization, globalization also we've completed. Go to that chapter, you will see जो restrictions है current account transactions के वही वहाँ पे है current and capital entirely. Then we have done this also we completed, this also we've completed, and think we've done one more chapter, right? And Competition Commission of India. So all the major chapters I have covered. You can now manage it. Just have to pull off a little bit more. That's it from my end. For TOPA, Transfer of Property Act, you will be in the Telegram and our WhatsApp group. I will post it there. Okay, that is it. So it will be only for some time period. Then I will make it private, that particular TOPA. That's it from my end. So I have completed TOPA, also one of the most important chapters. TOPA, be in our WhatsApp groups and our Telegram groups. I will send that chapter there. Okay, that is it from my end. Thank you very much for your patience and wish you all the very best. Your situational questions, pay attention. These chapters will come for situations. Contract Act will come as a situational question. Sale of goods, situational question. Your Competition Commission of India, a situation question. So just see how to write situation questions on the past year papers. Okay, so the WhatsApp link is invalid. There are many WhatsApp links in the description. Just see one of them will definitely work. Or just be in the Telegram group and then I'll share the WhatsApp groups also. Maybe the WhatsApp groups get full really fast. We have around 7 WhatsApp groups. So I've sent it in the description. Please join that. I will be sending TOPA, the 8-mark chapter also. So with this, I complete a major chunk for your EBCL subject. All the very best. And it's going to be a very simple paper. Take care guys. Good night. Okay, any one WhatsApp group you have to join. You have to join any one WhatsApp group because the content will be very there. You're welcome. You're most welcome. Clear the exam, that I'll be more than happy with that. Thank you. All the very best. Take care guys. Do you want me to take one more chapter? Do you want me to take one more chapter? A chotu sa chapter do you want me to take? Just put in the chat box if you all can sit. I will take it up. I was thinking of taking money laundering. If you all can sit and message, I will take it up. Otherwise, I think you all can manage. It's late. That's why I'm not doing more. Okay. So we will start with money laundering chapter. Okay. Starting with the money laundering chapter also. Okay, so give me some time, I'll just set it up. So give me 5 minutes, we'll start the money laundering chapter also. So 10 minutes break and we start with the money laundering chapter. money laundering EBCL में है lesson 90 की। Okay, so I will just take a 10-minute break and we'll start with this. Okay, we'll take a 10-minute break and we start with the money laundering chapter. A full chapter will be done. Pura chapter including the past exam question. I will be doing the full chapter including the past exam questions. Hi guys, am I audible? Can you just put on the chat box if it's whether I'm audible? I'll quickly take you all through the exam questions and this entire chapter overview really fast. Just put in the chat box if you all can hear me. Okay, great. So let's quickly begin with this particular chapter. Now, whatever I do, I complete everything from it, all the important points from exam point of view. So, whichever chapter I'm picking up, I'm not just running away with that chapter. I'm going properly with the topic. So, then you just have to do revision from your end. Okay. So, we'll start. Hi. So, we'll be starting with your prevention of money laundering. We have to understand the meaning of the term money laundering. Money laundering means to convert your black money into white money. That means to convert your illegal money and making it look white. So process of money laundering is a process of disguising the criminal proceeds and to disguise its illegal origin. So if I have to explain what is money laundering, laundering means to clean. So when you earn illegal money, it's dirty money, right? It's dirty money. So it's dirty to earn from selling drugs, through kidnapping, to terrorism, through illicit activities. Illicit means illegal activities, human trafficking. ये सब तरीके से bribes. These are all the sources of earning illegal money. Now, with illegal money, I cannot directly buy property. I need to disguise the origin. I cannot directly go and buy property, right? From with my illegal money, I'll get an income tax rate, and people will ask from how I got. So first, I have to convert it. I have to disguise it and make it look. I have to make it look legal. Legal money. Okay. So there are certain processes that can be done in real life even today, where you can convert your black money into white. Now with this legal money, you can now buy property, etc., and enjoy your money. And if anyone will ask you, you will say that this is how I got it, and it will look absolutely legal. Now let's see the process of converting your tainted money. Tainted means illegal or dirty money into untainted or clean money. Illegal proceeds can come from terrorism, selling guns, financial crime, smuggling, activities of organized crime, drug trafficking, prostitution. Now, from all these ways, you can earn money. Illegal means. Once you earn this, then what do you have to do? There is a three-stage process. Now, this is always a 3-mark exam question that comes from this chapter. 3 marks, 100% comes. Okay. So let's see the scheme of money laundering. It's 3 processes. The first is a typical money laundering scheme will be placement. Whatever you've earned, the illegal money, you will place it into the financial system. You will layer it, make it look legal, disguise its origin, and in the end, integration. Integration now, once it is clean, then you can use it and buy assets, etc. So the process of money laundering, it is an important past exam question. Placement first. It starts with whatever illegal money I have. Just think like washing your clothes. So dirty clothes are held in your hand. You place it in the washing machine. So you place it into the financial system. So you introduce it into the financial system. Then layering. Then you on the washing machine, it starts cleaning. So layering is all these techniques that you use to disguise the origin. So to camouflage, disguise the through various complex financial situations. Now there are multiple ways to launder your money. Not telling you now. Right now we are just discussing what is important from exam point of view. Then is the cleaning part. This is called as layering. In a series of conversion or movements of funds from different sources, the launderer simply wires the funds through various series of accounts across the globe to make it look legal. Once it is layered, it is cleaned, then now you will integrate it back into the financial system by buying. So this integration simply means now you will enjoy the money. You will acquire wealth, you will buy luxury assets, real estate, property, etc. Now you can happily buy. Now, what is the impact of money laundering? This is also a past exam question. What happens with impact of money laundering? So, okay. Now, what is the impact of money laundering? So, you will say it is very serious. If it is not checked, it is not solved, and these criminals are not blocked from laundering and enjoying this money, then it will lead to a serious issue in the country, because they will now capture all the political posts. They'll be so rich that everyone will have to listen to him. They will get more and more stronger, weaken the democracy, the ethical standards of the society, and ultimately laundering enables criminal activity to continue. Then comes prevention of money laundering is a global initiative. So globally there have been a lot of action taken in the Vienna Convention. They've said that prevention of money laundering was United Nations Convention against illicit drugs and narcotics. So the member countries wanted to criminalize money earned from drug trafficking. So if you remember, he is Pablo Escobar. He was one of the very big drug peddlers. He used to earn money and then convert it and was super rich. The government told that we will not leave you wherever you are. So what he did is he took his son and he went to the White House and he stood there and took a photo there. That's when we came to know that how powerful and daring person he is. So in Vienna Convention, they said that money earned from selling drugs, drug trafficking, should be treated as illegal and penalized. Then again, in the Council of European Convention, again a common. So worldwide, people started saying that let's make a policy to search, seize, confiscate proceeds of crime. Okay, lay down principles of international cooperation, because money launderers involve multiple countries to disguise its origin. So we require all the countries to be there strong to combat money laundering. Okay, then they say that we should facilitate international cooperation as regards to investigation, search, confiscation of proceeds, and this not only stopped that we'll make it a crime of drug trafficking, but they said even arms, ammunition, terrorist offenses, etc., should also be done. Then talking about the European Union money laundering directives, what did they say? They wanted to criminalize money laundering, maintain internal system to prevent money laundering, and identification of customers with whom they enter into transactions, and report suspicious cases. So this was there in the European Union. I'll give you a shortcut also to remember. In Basel Committee, they have all said that banks internationally should make their control so strong that they can identify customers who are illegal and who are fraudulent, and avoid suspicious transactions. Banks are not to be, they all agree that banks should not be made as a medium to launder money. Then came the International Organization of Securities Commission. They said that we should take steps to combat money laundering. So now these are so many initiatives internationally taken. So in case in the exam you don't remember, just write everything that money laundering should be made as a crime. Money earned from drug trafficking, terrorism activities uh, is should be made illegal. Next, the bank should not be made as a channel. Even the share market should not be made as a channel to launder money. And we should take internationally, countries should come together and cooperate and make a common policy to combat money laundering. General answer लिख के छोड़ देने का. Okay, in case if you don't remember. Now coming to one important thing is about FA, Financial Action Task Force. Very important. FAST This is a past exam question also. Now, Financial Action Task Force, super important. Super important. What did it say? History of money Financial Action Task Force. In response to the mounting concern over money laundering, the Financial Action Task Force on money laundering was established in the G Summit in Paris in 1989. So what is Financial Action Task Force जो एग्जाम में आ चुका है? It is an international intergovernmental body. मतलब it's not any one government's body. Many governments representatives are here, and the purpose is to develop and promote policies that combat money laundering and terrorist financing. मतलब हम लोग develop and promote करेंगे ऐसी policy जो money laundering को combat करेगी. It is a policy making body. It had spearheaded the efforts to adopt and implement measures to counterfeit the use of financial systems by criminals. So it has spearheaded efforts to adopt and implement measures to counter the use of financial systems by criminals. What the Financial Action Task Force can do, they will monitor, they will review, and they will promote measures and steps to combat money laundering. Now you can remember this also about Financial Action Task Force. Then came most important from exam point of view, in India initiative. So in India, we have made the PAMLA law, that is Prevention of Money Laundering Act 2002. Object is to prevent money laundering, confiscate properties which are earned from laundered money. Then offenses. So they said that whoever, let's see if I made a shortcut. Yeah. So they put a punishment that whoever is done money laundering. This punishment has come in the past exam question, so mark it is important. So punishment for money laundering is any person will be found guilty of money laundering for rigorous 3 years imprisonment, which can go up to 7 years, and fine of 5 lakh rupees. However, if you are involved in drugs and narcotic substances, then instead of the punishment can extend up from 3 to 10 years and fine up to 5 lakh rupees. The property can be attached which is earned through money laundering. However, it is a provisional attachment, temporary attachment. Till the final order is given, provisional attachment will only last for 180 days. And then once the property is attached, for example, किसी ने launder money से पैसे कमाया, someone has earned through laundered money. So then the Director General of Money Laundering will attach these properties. That is, you have seen though they put those barricades and this ताला लगा देते हैं उसके ऊपर कि ये अभी seal हो चुका है. They will seal the area, and within 30 days from the date of attachment, file a complaint before the adjudicating authority. Then they will go and file before the adjudicating authority. Adjudicating authority is the deciding authority कि भाई इसका asset है ये legal है या नहीं legal है. अभी temporary attach कर दिया, you attach it temporary, but is it legal or no? Then the adjudication is given under section 8. On receipt of the complaint from the Director General, the adjudicating authority may serve a not less than 30 days notice on the person calling him to indicate a source of the income out of which he has acquired the property. So they will ask him, how did you acquire the property? Come and explain. Then after hearing listening to them and listening to both the parties, they will pass the order. And if the order is against you, then as per section 9, the central government will become the owner of the property. Now, most important part is here. Most important is section 12 to 15, the obligations of banks and financial institutions. This come multiple times in the exam. Section 12 says every bank shall maintain records of all transactions, its nature and value as may be prescribed, which have occurred within a particular year. The information is always given to the Director General of Money Laundering. If this will be preserved for a period of 10 years. This is section 12. Section 13 says that the director may call for the records of any transaction, and if he finds that the banking company has failed to retain the records, he may levy a fine on the bank. This is section 13 and 14. 15 says that the central government may prescribe procedure for maintaining and furnishing information for the purpose of this section. So section 13 to 15 puts an obligation on banks to maintain information. Know your customer initiative, very important. We all have done our KYC, yes or no? So why do they do the KYC? So that we come to know who is the person, how much does he earn, etc. We all link the Aadhaar card with the PAN card. Why? Aadhaar card is your personal information where you stay. PAN card is your income proof. So then we will come to know what all you are doing. The objective of KYC, know your customer, banks have to do that, is to prevent the banks from being used by the criminal elements for money laundering. KYC mein what will they see? Who they will accept, they will how will they identify the procedure, they will monitor the transaction, and risk management techniques will be put. Information that has to be preserved, what is the nature of transaction, amount, date, and details of the parties. You have to preserve the records of all the transactions, generally for 8 years. An introduction to new technologies. Nowadays we have debit card, credit card, smart card, gift card, buy now, pay later cards, etc. Banks should pay special attention to money laundering threats that may arise due to these new types of internet banking that has come. Many banks are engaged in the issuing of electric cards, that is ATM. Banks are required to have full compliance with the KYC, anti-money laundering steps. Okay, they should take appropriate measures for KYC, and it is also desirable that the agents are also subjected to KYC measures. Now, if you find that there is something wrong, you can report it to the Financial Intelligence Unit of India. Okay, so the exam questions are: what is money laundering? Explain what is the punishment of money laundering. Punishment of money laundering has come multiple times. You will define it right. What are the effects of money laundering? So you will say it is very serious and it will the crime will keep on continuing. What do you mean by KYC guidelines by this? Again, very important. You have to know KYC is know your customer, anti-money laundering laws, and combating of financing of terrorism. So all this is important. Next is what information should be preserved by the banks under money laundering law. So we've seen that under section 12 to 15 contains the obligations on bank. Every bank shall maintain all records, furnish to the director, maintain the records of any clients and beneficial owners, preserve the nature of transactions, etc. So this is important, and that is it. We are done with the chapter. So I've covered everything, including the past exam questions also. So that is it from my end. Do like the video and share it with your friends, whoever needs it, and do subscribe to the channel as well. Wish you all the very best for your exams. Do really well. Start writing until they don't take away your paper. Keep writing. Good luck, and if you got a, I'm sure you'll get a positive result. Don't forget to share. It'll be very nice to hear that. Take care. Good luck.